We're going to jump in and get started. And you'll remember, we're in the throes of our offer to purchase and contract in Unit 10. So remember the form that we're looking at right now. This is the standard. This is the one provided to us by the North Carolina Association of Realtors. This is not the only contract that we can use, though. You may use another contract. Remember, as long as it was drafted by an attorney, and there's also a commission rule, it's got to meet the requirements of that commission rule. We're not getting into that commission rule in pre-licensing, but no, there's a rule that regulates what contracts we can use. You know, some things that we introduced you guys to last week, we started talking about due diligence and due diligence fees and due diligence period and earnest money. If you use, for example, a builder contract, a builder's contract, they may not have those terms, right? They may not have due diligence or earnest money. If you use a different contract, the fixture list might look different. So they're not all exactly the same. The reason we go over this one is because this is the most commonly used one. This is the one you're going to see the most often. This is the one you're going to be the most familiar with. However, if you do work with a buyer that goes after new construction and the builder has their own contract, do you think you should familiarize yourself with that contract on behalf of your buyer? Do you think you should look it over and know what the terms are so you can help your buyer? I should see head shaking yes, because isn't that what we're hired to do? Isn't that the representation of our buyer? So just introducing you to the standard, knowing there could be others out there. As a reminder, our highlighted offer to purchase and contract is in the Campbell folder. Good morning. Our highlighted offer to purchase and contract is in the Campbell folder. So we are, get my highlight. We're in the Campbell folder, and specifically we're looking at the offer to purchase and contract with highlights. The reason it's highlighted is because it's in the syllabus. And the Real Estate Commission says if it's in the syllabus, it's a good candidate for a test question. If you got a chance to look over this weekend, you saw there was a lot highlighted, didn't you? So this form is definitely one to be familiar with. So we started, and we're in the throes of this discussion. So quick recap. We started with the first thing that we see in our offer to purchase and contract is terms and definitions. And we spend the first like 2.5 pages just defining things. At a minimum, I think you guys should look at these terms and definitions because it defines various things like due diligence period, earnest money deposit. You know, it's for the buyer and the seller because they're the parties to the contract, right? But we need to be familiar with these terms and definitions so we can help our buyers and sellers get through the transaction. So we started defining things, terms and definitions. Over on page 2, we talked about the earnest money deposit. We talked about the effective date. The effective date gave us that magic moment in time when it goes from being an offer to a contract. We need 2 things to happen. We need the offeree to accept. And for your test, when we see the word accept, what does that mean? What do we know that means when we see the word accept? We know, good job, guys. We know it's been signed. For your test, for pre-licensing world, you don't have to stop and ask yourself, has this been signed or not? When you see the word accept, you know it's been signed. And then the second thing we need to have happen is that communication of acceptance has to go to the person that made the offer. So the person that makes the offeror has to know that their offer's been accepted. Doesn't that make sense? If you make an offer to me and I sign it, but I never tell you, how do you know we're under contract? How do you know you're legally obligated to sell me or buy a house from me? So we have to have acceptance, and then we have to have communication of acceptance. We talked about different forms, different methods of communicating acceptance. And bottom line, what we're communicating is the fact that it's been signed. And we can communicate that acceptance on any form of communication that the parties agree to. So if they agree, if they provide their email and their phone number, both are acceptable forms of communication. Still defining things, quick recap. We talked about due diligence, the due diligence fee, and then the due diligence period. Due diligence is paid directly to the seller. Earnest money goes into an escrow account. If we close, if we make it to closing, both the due diligence and the earnest money are going to be credited back to the buyer. It's money they've already paid. They've prepaid. Think of them as a deposit. They've prepaid that money. So if they make it to closing, they're going to get a credit back to it. That's that much less that they have to bring to closing. If the buyer exercises their right to terminate within the due diligence period, the seller will keep the due diligence fee. That's what the buyer paid for. But the buyer's going to get their earnest money back. So as a buyer's agent, we want to try to get through their inspections or investigations, which we're getting more into that contract to closing process. But we want to get through as much as we can during our due diligence. So if we have to terminate, worst case scenario, we have to terminate. We can still do so within the due diligence period and get our buyers their earnest money back. That's the best thing we can do for them, is get them their earnest money back. Is something better than nothing? Yeah. If the buyer terminates after due diligence, after the due diligence period is over, now they are in breach. They had this free look period. They had this opportunity to terminate. And the contract even says they can terminate for any reason or no reason during the due diligence period. So they have this free opportunity, free. I mean, they got to pay for the fee, of course, the due diligence fee, but they're not bound to the seller. The seller can't sue them if they terminate. If they terminate after the diligence period, now they're in breach. The seller's going to keep the due diligence fee, and the seller's going to get the earnest money deposit. And as we go further and further in our contract, we're going to get to paragraph 23. And paragraph 23 actually spells out what happens if the seller breaches, what happens if the buyer breaches. So that'll be a good opportunity for us to review that as well. So there's a fee and a deposit made at the time that we go under contract. One check made out to the seller, one out to the buyer. The other thing that we defined is the difference between settlement and closing. Settlement is where the attorney is gathering information. The attorney is getting buyers and sellers signatures, the signatures on the documents that they have to bring. If the buyer, or when the buyer has to bring any money, they'll provide that during settlement. If the seller has to bring money, they'll provide that during settlement. We all leave settlement, and then the attorney puts the finishing touches on it. And that process is known as closing. And the very last act, the very last thing that happens is the attorney records the buyer's brand new deed at the Register of Deeds, the county where the property is located. Then and only then is it a done deal. Could you have things that happen between settlement and closing? Could the internet go down and we couldn't e-record? Yeah. Could the power go out? Sure. I mean, there are still things that can happen. So that's why we're close to celebrating at settlement, but we're just not there yet. Closing is the final last act. And then we talked about fixtures again. We introduced you to fixtures in Unit 2, the idea of fixtures versus personal property. So make sure you review those. Here's our place for personal property. A fixture is meant to stay. Personal property is meant to go. So if either are going to do the opposite of their intent, if a fixture is going to go or personal property is going to stay, then we need to include it in the contract. Remember the parole evidence rule from Unit 9 says the final written word of the contract is going to prevail. Any previous negotiations don't matter. I just spilled coffee all over myself. That was smooth. At least it wasn't too hot. Okay. And then we said we got to provision 4. We got through 4. Provisions 4, 5, and 6 are all about the buyer. So as a buyer's agent, 4, 5, and 6 are the ones that we definitely want to make sure we're having a conversation with our buyer about. So you see, it helps put words in our mouth. Provision 4 goes over the due diligence process. We're going to talk more about the loan as we get into financing. Various things that the buyer may want to consider investigating to learn about the property, to decide if they want to complete the transaction, various inspections, etc. If they have to sell or lease an existing property before they can buy yours, the advice is that they close on their other property prior to the end of due diligence, or be reasonably satisfied that it will close. I think this is one of the most important sentences in the offer, a 16-page offer to purchase and contract. The property is being sold in its current condition. Isn't that just a fancy way of saying as is? So the buyer has all their inspections and investigations done. Can they ask the seller for repairs? Can they ask the seller to fix something? Yeah, they can ask. Is the seller obligated to do any repairs? No. Good job, guys. So the seller can say, no, I'm not going to fix that. The seller can say, I'm going to fix this, but I'm not going to fix that. The seller can say, I'll fix it all. This is entirely up to the seller. We need to prepare our buyers for this. Just because they submit a repair request doesn't mean the seller is under any obligation to do it. And if the seller says, no, absolutely not, I'm not fixing it, now the buyer knows what they know about the property and they have a decision to make. Do I move forward with, or do I terminate this transaction? Buyer's due diligence, buyer's right to terminate. Again, as long as they deliver the termination, they have the right to terminate. Here's the any reason or no reason. All they have to do is send written notice of termination to the seller. They don't have to tell the seller why they're terminating. They can if they want to, but they don't have to tell the seller why. All they have to do is just send written notice of termination. By the end of their due diligence period, that's a time being of the essence. And if they do, they will, earnest money deposit shall be refunded to the buyer. So as long as they terminate by 5 p.m. on the due diligence date, earnest money deposit shall be refunded to the buyer. And then the last thing we said before we left last week, again, a very important sentence. Closing shall constitute acceptance of the property in its then existing condition unless provisions otherwise have been made in writing. Once you hand them the keys, you guys, once that deed gets recorded, it is a done deal. There's not a 30-day return policy. There's no takebacks. There's no returns. So this is why we're helping our buyers learn about the property. So when we get to this point, when they do get their new deed on record, they're not wondering what other obligations the seller still has to do. They are done unless provisions otherwise are made in writing. So that's a very quick recap of what we covered so far. Do I have any quick questions on things that we've covered so far in the offer to purchase and contract? Moving right along, we're going to get through this. We got a few other things to talk about in Unit 10. Provision 5 is buyer representations. This is information that the buyer is disclosing to the seller. And the seller should be able to rely on this information when deciding if they want to enter into a legally binding contract with this buyer. So the buyer's got to be truthful, and the seller should consider it. So the first thing that the buyer needs to represent is, how are they going to get the funds to complete the purchase? Do you think that's important for the seller to know, that you got the money or you can get the money? Absolutely. So if it's cash, they're going to pay cash. We have a box here. What this blue note says is that the seller is advised prior to signing this offer to see the buyer's proof of funds. They can call their bank and get a letter from the bank saying there's enough money in the bank to buy the house. Sellers shouldn't just rely on the buyer's words. Remember, these are complete strangers. We typically don't like to trust strangers, do we? Especially when it comes to somebody buying your house. Yeah, I got the cash. No problem. Y'all gonna believe that? Or you want to see a letter from the bank? So that's the advice given to the seller. Or if the buyer's going to get a loan, if they're going to get a first mortgage loan, second mortgage loan, the type of loan, FHA, VA, conventional, all that we're going to talk about in our financing units. So hang on to that for just a second. Accompanied with the offer is generally a pre-approval or a pre-qualification letter from the buyer's lender. Again, we'll talk about that in financing. The pre-approval is no guarantee. Once we go under contract, we still have to go through the loan approval process. So all the pre-approval letters basically saying the lenders crunch the numbers real quick and yeah, we think you can pay this much. They haven't verified, they haven't run it through underwriting, again, talking about all that process. But at least they have had a conversation with the lender, and that's the letter that we're sending to the seller. We're accompanying with our offer, so it's going to support this information on page 6. We talked about a contingency. Buyers are not conditioned upon any loans or other sources. There are no built-in contingencies in our contract. So remember, a contingency in this case said, if I can't get a loan, then I can't buy your house. So if we form that contingency, if you and I agree to form that contingency and I can't get the loan, then I'm not legally obligated to buy your house. That's what a contingency says. If this doesn't happen, then we're not bound to each other. Again, there are no built-in contingencies. There used to be. Did anybody buy a house, I don't know, 15, 18, 20 years ago? Long time ago? You probably had a loan contingency when you bought your house 20 years ago, but that's gone away. That does not exist anymore. The parties can agree to add a contingency. And if they do add a contingency, then it becomes binding. If I can't get the loan, then I'm not legally obligated to buy your house. And I don't have a form. We don't have pre-printed forms for contingencies. So if your parties do want to add a contingency, what do we need to do? We're going to draft one up for them? That's really nice of you. No, we're not going to draft one up for them. We're going to call their attorney. We cannot draft legally binding documents. I know it's easier for you to do it. Guess what? You and I are a heck of a lot cheaper than an attorney. But we cannot draft legally binding documents. Creating a contingency. Still under buyer representations. They are representing to the seller that they do or do not have to sell or lease another property in order to buy yours. Again, I'm not creating a contingency. We are just notifying the seller, I have a property to sell or lease before I can buy yours. And then we have, if we do have to sell or lease, then we're told to check if applicable. The buyer's other property is under contract. Or the buyer's other property is not under contract. We're getting ready to list it. It is listed, or we're going to go for sale by owner. And again, we're reminded that's not conditioned upon the sale or the lease. If the parties agree to make this condition, an appropriate contingency addendum should be drafted by an attorney. See what the contract does for us? It takes a lot of the guesswork out, doesn't it? So if we're familiar with the contract, then we know when to call an attorney and when not. Performance of buyer's financial obligations. There's nothing else other than loan approval that would prohibit the buyer from getting the loan. The buyer has to represent whether or not they've received the RPODs and the MOG. the residential property and owners association disclosure statement, and the mineral and oil and gas rights. We talked about both of those back in Unit 8. These are the seller representations about the properties, the RPODs, and the MOG. The buyer just has to acknowledge that they have received a signed copy of the RPODs. In this case, they have received a signed copy, or they have not received a signed copy. Remember, if they don't get a copy of either of these disclosures, this could be an out for the buyer. They could terminate. This is one of the cases they could get their due diligence fee and their earnest money deposit back. As the listing agent, don't give your buyer that opportunity to terminate and get their fee and deposit back. We should be getting these forms from our seller back in the day when we list the property, so we have them ready. The buyer's got to represent that they have or have not received the RPOs. Again, we go through that same little exercise with the MOG. They have received it or they have not. And if they have not, it spells out their remedy. And then 6 is buyer obligations. So these are the things that the buyer is responsible for themselves. What are their expenses and fees, for example? Buyer's responsibility for special assessments. We define special assessments back in the first provision. Special assessment, it could be by the government, maybe a government special assessment. They're going to install sidewalks or street lighting, for example. You could also have a special assessment from an HOA. So maybe they're going to repave the parking lot or put new roofs on the townhomes. Either special assessment will qualify here. And the buyer's going to be responsible for paying those special assessments, anything that's approved after settlement. So if it's on the table for discussion, we haven't voted aye yet. It's still on the table for discussion. It's not an approved special assessment. And if it gets approved after settlement, then the buyer will be responsible for it. When we look at the seller responsibilities in just a second, we're going to see what their responsibility is for special assessments. We're also going to see that the seller should notify the buyer of any proposed special assessments that they are aware of. So if they know something's in discussion, they should communicate that with the buyer. We'll see that in just a second. Buyer's responsible for their costs, anything about getting the loan, anything about their due diligence process, their inspections, appraisers, survey. Buyer's responsible for their costs. And then authorization to disclose information. As agents, we need to send our executed contract to various people. The buyer's lender needs a copy, the attorney needs a copy, for example. And this provision just gives us permission to share that contract. Even though it's not our contract, it's theirs. We have permission to share that. So again, 4, 5, and 6 are all about the buyers. Buyer's agents, make sure you're having these conversations with your buyers. Again, you guys, they're not reading this. So make sure we're helping explain it to them. Questions about buyers in the contract, 4, 5, and 6. So if 4, 5, and 6 are about the buyer, that means provisions 7 and 8 are all about the seller. Listing agents, make sure you go over 7 and 8 with your seller, because these are the terms that are specific to them. And we start, 7 is seller representations. Again, this is information that the seller's providing to the buyer. And the buyer should be able to rely on this information. It should be accurate. And the buyer should be able to rely on this information. So the first thing the seller has to represent to the buyer is how long they've owned the property. They've owned it for at least 1 year. They've owned it for less than 1 year. They don't yet own the property. This could be important to the lender. For example, some loan programs require sellers or owners to own a property for X amount of time before they can sell. Who typically is the one that owns it for less than a year? Typically. Those are your investors, aren't they? Your house flippers. They buy it, they gut it, they flip it, all new, except the bones, and then turn around and put it back on the market. Some lenders, some programs care if it's a flip or not. Some don't, some don't. It all depends on the lender and the loan product. They're all different. So the seller just needs to represent how long they've owned the property. If the property was built prior to what year? 1978, then the seller is going to include the lead-based paint or lead-based paint hazard disclosure addendum. We talked about lead-based paint in Unit 20, our super scary environmental unit. If the property's in an HOA, the seller needs to disclose, they need to share as much information about the HOA as they can. Provide the covenants and the articles of incorporation and the bylaws, the parking restrictions, whatever information they have, the seller should provide. This exact same verbiage also shows up in our listing agreement. So listing agents, we can have this conversation with our sellers long before a buyer ever shows up, right? Before we ever list the property, we can tell our sellers, let's start gathering this information, because you know what? A good buyer's agent's going to ask for it. So let's start gathering this information now, knowing we're going to see it again when we get to our contract. And then we have a place to actually name the HOA. The dues are X amount per month, per quarter, per year, however that HOA is set up. Some places may have multiple HOAs. So we got two different places. You might, for example, have a mandatory HOA for the common areas, and then you have an optional HOA for the pool, for example. So you may have a couple different things going on with the HOA. Again, sellers just providing the information that they have so the buyer can take that into consideration. Fuel tanks are underground storage tanks. We talked about, again, in our super scary environmental unit. So to the best of the seller's knowledge, there is or is not a fuel tank on the property. If yes, complete the following. So now we need to identify the tank. I got a place in here for 2 tanks. Is it currently in use or not? Is it owned or leased? If it is leased, who are we leasing it from? Is it above ground, below ground? What kind of fuel's in it? And then who do we contact? Again, the seller can only represent what they know. So if they have an old abandoned underground storage tank buried in their property, they don't know about it, they can't disclose it. Could have been the previous owner buried it. Tanks are included in the sale. Anything that's described above is going to be included as part of the purchase price. Just a couple more notes. I'll let you guys look at that. And then seller's obligations. Again, what are they expected to do? What are the duties of the seller? The biggest responsibility of the seller is to provide free marketable title. Clear marketable title. That's the word I want. So the biggest responsibility of the seller is that clear marketable title. Remember, the buyer's attorney, the closing attorney, represents the buyer. So the buyer's attorney is doing that very thorough search of the public records to see if there's anything that could negatively affect the title. And if so, then the attorney will get with the seller to clear up before settlement. Isn't that what's in the best interest for their buyer client? And that's what they can do to make sure their buyer client has that clear marketable title. So the attorney is the one that does the thorough search, determines the issues, and then if anything, gets with the seller. Seller has an obligation to provide reasonable access to the property through the earlier of closing. The seller can't deny the buyer's home inspector from coming on the property. The seller can't not allow the buyer's appraiser to come on the property. Remember, the buyer's in due diligence doing all their inspections and investigations. And if the seller doesn't let any people on this property, the buyer can't do their investigations and inspections, do they? So even though we're under contract, the seller still needs to be prepared for home inspector, pest inspector, survey, appraiser. Everybody's got to make appointments before they go. People just can't show up and start working. Remember, it's not the buyer's property yet. So the seller's still the one that lives there. They still have the right to know when people are coming on their property. So the buyer access to the property is to conduct their due diligence. If the seller does do any repairs, the buyer has the right to come back and investigate those agreed upon repairs once they're complete to make sure they're done in a satisfactory manner. The home inspector sometimes will go back and re-inspect for a lesser fee, those things that we agreed to fix, for example. So they have the right to come back. And then the buyer has the right, and this one's big, to conduct a final walkthrough. We want to do this final walkthrough as close to settlement as we possibly can. I do it on our way to the attorney's office. You guys remember that sentence? Closing constitutes acceptance as the property in its then existing condition. If we don't do the final walkthrough, how does the buyer know what that existing condition is? Everybody with me? So we do the final walkthrough as close to settlement as we possibly can, so the buyer knows what they're signing when they get to the attorney's office. So what if? I hear you. What if? What if the home is not in satisfactory condition? What if the seller left a bunch of junk, a bunch of garbage, a bunch of debris? What if we've never seen this home vacant? And we do the final walkthrough and we're seeing it vacant for the very first time ever. And the final walkthrough reveals why there's a picture here. And the reason there's a picture here is because there's a huge hole in the wall and we're seeing it for the first time. So what if we're not satisfied with the final walkthrough? We got two choices. We either call the listing agent and say, we need to get this fixed. We may have to delay settlement, but my buyer's not buying until this is taken care of. Or our buyers go to the attorney's office, sign, and accept the property in its existing condition. We got two choices. We either work it out or we go and buy. Everybody with me? And this is a conversation we need to have with the buyers. If you sign, you're accepting the property in its existing condition. So if you sign, you're accepting this big hole and you're accepting all the trash and everything. If you don't want to sign, let me call the listing agent and see what we can be done. Again, we may have to delay settlement if that happens, for the seller to get in and get things cleaned up. It happens, you guys, which is why the final walkthrough is so important. You may have a buyer say, nah, I don't need to do the final walkthrough. If your buyer says no, the highly recommended advice is that you, as their agent, still goes to do the final walkthrough. And if you're doing it without your buyers, I highly recommend you document that walkthrough. Take your phone and record. These things are tethered to us anyway, right? So use these things. And that way, if the buyer moves in, there wasn't a hole here, but the buyer moved in and put a hole here. Isn't it their word against the sellers? So you doing that final walkthrough and you documenting. So the final walkthrough, very, very important. I've not had many buyers not want to do the walkthrough, but occasionally I have, and I still do it without them. Questions on that? Seller also needs to provide existing utilities, operating at whose cost? They got to keep the power on. They got to keep the water on. How else are we going to do our inspections and investigations if we don't have power or water. So make sure the seller keeps, even if they're not living there, make sure they keep these things on until the day of settlement, until the day of closing. Removal of seller's property, all personal property, which is not of the part of the purchase, garbage and debris. Sometimes sellers think they're leaving gifts. Sometimes sellers think, well, this grill, we're just going to leave the grill. The buyer will appreciate a new grill. The seller just don't want to move it. But guess what? If the buyer wanted the grill, they would have asked for the grill when we went under contract. The buyer probably has a nicer, better grill. They're going to bring their own grill. So don't, as listing agents, don't let your sellers leave gifts. If it's not part of personal property in the contract, the buyer's probably going to consider it garbage. And that's what we need to make sure that the seller gets out. An affidavit and indemnification agreement. The sellers are expected to sign something at settlement, one of the forms they sign, that says nobody can come claim a lien on the property after settlement. You guys remember the mechanics liens? And the mechanics lien, they have 120 days after the work's complete. So let's say the buyer asks the seller to do repairs. We're under contract. The buyer asks the seller to do repairs. And the seller says, yeah, I'll do them. Sure, no problem. They have the repairs done. They don't pay the mechanic. We go to closing. The mechanic files a lien. Remember, that's a specific lien, which means it attaches to what? The property. So your buyer in their brand new home has a lien on the repairs that the seller agreed to do. That doesn't sound good, does it? So how do we avoid that? Well, one thing that the seller is going to sign on behalf of the buyer's title insurance policy is that everything's been paid. The seller is going to sign this affidavit that says this has been paid. And if it comes up later that it wasn't, the title insurance company has the seller's affidavit and they can go after them in a court of law. The other thing we can do to protect our buyers when we're asking for repairs, put verbiage in there that specifically says something like paid in full invoices to be provided. So we can see that the work was done. We can see who did the work, but we can also see that it's been paid. So a couple of different ways to protect our buyers from that happening, in addition to the affidavit that the seller has to sign. Good title legal access. We actually read this paragraph back in Unit 5. It's in your book. Seller's going to deliver a general warranty deed, recordable form, no later than settlement, convey fee simple marketable insurable title without exceptions to mechanic liens, or free from anything else that we could have identified with a title search. Mentions easements. Property must have legal access to a public right-of-way. The seller's going to pay for the preparation of the deed. Remember, we talked about seller's debts. We said seller pays for CDE. So deed preparation fee is one thing that the seller is responsible for. Again, more on that in 21 when we actually get to go to closing. Seller's also responsible for paying excise taxes that we talked about back in Unit 5. So the contract spells out things that are responsibility of the seller. And then we're going to say this deed is to be made to, and we're going to put in the names of all the buyers that need to appear on the deed. Let me rephrase that. We're going to put in the full legal names of all the buyers that need to appear on the deed. If we want to identify their relationship, for example, we can identify them as husband and wife. So the attorney will know that they're going to take title. It's Tennessee by the entirety. If you have unmarried people, again, you may want to identify their relationship. Mother-daughter, for example. So we know they can't take Tennessee by the entirety. And now the attorney knows to have that conversation about joint Tennessee or Tennessee in common. So identifying the relationship of the buyers that are going to be on the deed can help the attorney. Agreement to pay buyer expenses. Seller shall pay at settlement X amount toward any of the buyer's expenses, toward any of the buyer's closing costs. Is the seller under any obligation to pay any of the buyer's expenses? Do they have to? No. Can we ask? Sure. But I'm telling you guys, what we've seen in this crazy multiple offer world, what we're seeing a lot is a big zero. Now that market's going to swing back and we're going to be back in a buyer's markets and we're going to see that number go up. Buyers are going to take advantage of it. Their different loan program will have limitations on how much the seller can pay. Just get with your lender. But, you know, get completely negotiable term. Buyer can always ask, sellers under no obligation to pay any of their closing costs. Here's our owners association again. So we just said that the buyer's responsible for paying anything that is approved after settlement. The seller is responsible for paying things that are approved prior to settlement. So everything that's already been voted yes, government special assessment or an HOA special assessment, once it's been confirmed, the seller is responsible for paying it prior to settlement. Buyer pays it after. Property taxes, if the seller never paid 2022 taxes, they'll have to take care of that along with any penalties. Negotiated repairs. This always makes me laugh. Negotiated repairs and improvements shall be made in a good and workmanlike manner. Wasn't that subjective? Some people are more handy than others, yes? We all got access to YouTube and a hammer. Does that mean we all know what we're doing? No. This is why the buyer has the right to verify those agreed upon repairs. Again, one thing we can do to protect our buyer, if you want a general contractor, a certified plumber, electrician to handle the repairs, put it in the repair request, make that part of the agreement. So the seller can't do the electrical work themselves. The seller, if they agree, would have to hire an electrician, a certified electrician. Handyman specials. Ooh, y'all wait till you start seeing those. You're going to see some fun stuff with those. Mark my words. Home warranty, whether or not no home warranty to be provided by the seller. The buyer can get a home warranty in which the seller will pay for, or the seller already has a home warranty. So again, they're just representing to the buyer the status, if any, of a home warranty. And then seller's breach, again, we're going to talk about breach for both parties in paragraph 23. So 7 and 8 are seller's representations and our seller's obligations. Questions on sellers? More information about the owners association. Again, we've already broken it down, but this gets specific about things that the seller's responsible for, things that the buyer's responsible for. Keeping in mind anything's negotiable, but this gives us a place to start with our owners association. Prorations. There are certain things, shared expenses, if you will, at settlement, that the parties are going to prorate between the two of them. Now, we're going to talk about prorating in Unit 21, excuse me. We're going to pick up our calculators and we're going to learn how to prorate. So we'll see this again, but let me ask you guys something. If you were buying my house today, April 25th, is it fair for either one of us to pay this year's taxes? Is it fair for either one of us to pay this year's HOA dues or this month's HOA dues? No. So what prorating does is it makes it fair. It takes these shared expenses, for example, this year's taxes, and it divvies it fairly between the two parties. Nobody should pay anybody else's bills unless agreed. So we're going to talk about prorating and how we prorate, give you guys something to look forward to. Condition or risk of loss. We're going to see this again in unit 11, which is our insurance unit. No, 13, sorry, insurance unit. If the property is not in substantially the same or better condition at closing, as of the date of this offer, reasonable wear or tear expected, the buyer may terminate this contract, deliver written notice to the seller, and if they do terminate because of the property, they will get their due diligence and their earnest money back. If the property is not in such condition and the buyer does not elect to terminate, the buyer shall be entitled to receive, in addition to the property, the proceeds of the seller's insurance claim. So let's say we go under contract and the house burns down. It's not over yet. The buyer has a choice, don't they? They can buy and take the property subject to the seller's insurance, or they can terminate and get their earnest money and due diligence back. I've never had this happen, but if I did, and I were a buyer's agent and the house burned down, I would tell my buyer that they need to make 2 phone calls before they make a decision. Who do you think the first phone call's to? Their attorney. The second one is going to be to the seller's insurance company. I need them to get more information before they make a decision about whether or not to terminate or not. Again, there's very few times, you guys, that the buyer could get their due diligence back. House burns down, they choose to terminate, they could get their due diligence back. If the seller is in breach, if the seller breaks the terms of the contract, the buyer could get their due diligence back. And the other one we just said is if they don't provide the RPODs and the MOG, and they terminate within that 3-day period, they could get their due diligence back. That's it. Any other reason, the buyer's not getting their due diligence back. The second part of this is risk of loss. Again, it's still the seller's property until closing. So the seller needs to maintain homeowner's insurance until closing. So many sellers, we go under contract and they say, I'm going to cancel my owner insurance. No, it's still your home. It's still your property. So the seller needs to have that insurance. Again, we'll talk about insurance in unit 13. Delays in settlement. Delays just happen. Anybody ever bought a house? And anybody ever have a delay? Did you close on the day you were supposed to? Some of you did, good. And sometimes they do close on time, but guess what? Sometimes they don't. Delays just happen. Maybe the lender couldn't get his final loan approval. Maybe in the walkthrough, we found a bunch of garbage in the living room and the buyer didn't want to buy until they got that taken care of. I cannot tell you I don't have a crystal ball. So I can't tell you all the things that could cause delay. Anybody ever buy new construction? My goodness, you can bank on delays with new construction. This is what I have to say to you. Delays just happen. We have a 7-day delay built into our contract. That 7-day delay means that the non-delaying party can't terminate for the delay. 7-day delay means we have 7 days where everybody just sits still and be patient. Fingers crossed, we can get whatever that is to work out. After that 7 days, the non-delaying party can choose to terminate. I always tell my guys, sellers or buyers, to have a plan B. In the event that it gets delayed, have a plan B. I don't want anybody sleeping in a U-Haul truck tonight. So have a plan B. It just happens. Remember what we said? What if the internet goes out today? What if the power goes out at the attorneys and they can't e-record, right? There's no way we can predict everything possible. But what we can do is have that expectations that delays just happen And so the sooner we can prepare our parties for this, the less likely they are to be sleeping in the U-Haul truck tonight. So have them prepared. Possession of the property, possession including all means to the property, which is keys, security codes, garage door openers, shall be delivered to the buyer when? Upon closing. They should not be getting keys at settlement. They should not be getting access to the property at settlement, which means after it closes, they either need to go back to the attorney's office and get their keys, or they need to meet up with you somewhere if you have their keys as the buyer's agent. But the buyer should not be getting access until closing because it's not their property yet. We may have an opportunity to do a buyer possession before closing or a seller possession after closing. These are two different agreements by the buyer and the seller. We'll talk a little bit more about those when we look at our forms. And we also see these again in the insurance. Addenda. One thing I didn't point out that you guys are going to notice once you spend more and more time with this contract, scattered throughout the contract, when it comes for us to use a form, when a need arises for us to use a form, it'll tell us. So again, being familiar with the contract will let us know when we're going to use the lead-based paint or lead-based paint hazard addendum, for example. So what this section does is kind of give us a little checklist. Listing agent, this page tells you what addenda you should have included in your offer. Buyer's agents, this gives you the opportunity to make sure all applicable addenda are provided in your offer. So we use it as a little checklist, make sure we got everything. We're going to talk about some of these addenda, not all of them, but we're going to talk about the more commonly used ones in just a bit. Another reminder, how many times do they have to tell us, right? Real estate brokers are not permitted to draft. We cannot draft legally binding documents. So again, our contract reminds us of this periodically. Questions so far? We're close. Where are we? We are page 12. So let's go ahead and take our break. And when we come back, we're going to finish this section up and finish up in unit 10. So let's take 10 minutes. We're back. Let me, cameras are coming on. Make sure I can see you as well. So I'm going to take attendance. Let me just point out your book, page 292. 292 talks about the delay in settlement. 292 in your book, does it still say 14 days in your book on 292? Does it say 14 days or does it say 7? They just changed that like within the last year or so. So it might take a minute to catch up. So if it says 7 in your book, no, it says 14. Okay, so y'all make sure you make that correction in your book on page 292. They've changed it. It just takes time to get caught up. Remember, we're always referring to the current contracts for the current information. I'm a member of, we got lots of private agent Facebook groups out there. And on one of mine the other day, we had an agent saying that they went to closing, took her buyers to closing, and the seller never showed. And they sat there and sat there and sat there. And the listing agent called the seller and said, where are you? And the seller never called back. The seller never answered. The listing agent couldn't get a hold of them. So after sitting there for a while, they just said, there's nothing else we can do. So they all got up and left, wondering what was going on. Where's the seller? Y'all know where the seller was? That morning, they got arrested. They couldn't come to closing. That's a reason to have a delay in closing. You need both parties, right? And that's why we don't have a crystal ball. I can't tell you what may go wrong. I can't tell you that the seller is going to keep themselves out of jail, right? But that's why we have this built-in delay, because things happen. Everybody get that edit? Page 292 in your book. Some boilerplate stuff of your contract. What I mean by boilerplate, just typical verbiage that you're probably going to see in most contracts. We talked about an assignment in Unit 9. An assignment, you're transferring your duties and responsibilities. Page 292, under delay and settlement, your book says 14 days. The contract says 7. Edit your book to say 7-day delay. In an assignment, all the terms stay the same. The only thing that changes is the name of one of the parties. Whether or not a contract can be assigned has to be spelled out in the contract. So our standard contract says it may not be assigned without written consent of all parties. So this could be assigned if all parties agree to it in writing. Have your attorney involved or have your client's attorney involved to make sure that we're properly assigning the contract. There's also something called a tax deferred exchange. We're going to talk a little bit more about this in Unit 13, but this is an IRS program for the investor. And what the tax deferred exchange does is it allows the investor to defer paying capital gains taxes that when they're using the proceeds of the sale of this investment property to purchase another investment property. So as long as they're selling an investment property and buying an investment property, they can defer, they can withhold paying their capital gains taxes. So we'll talk about capital gains, tax deferred exchange. I think I just gave you the wrong unit. All that's coming down in Unit 18. You get to think like an accountant in Unit 18. Parties to the contract, here it is. Remember we said last week, death will terminate an offer. Death will not terminate a contract. This contract shall be binding upon and inure to the benefit of the buyer and seller and their respective heirs. When do heirs kick in? Upon death. So death is only an out when we're negotiating the offer. Once we go under contract, if either party passes away, their heirs are expected to carry through with the terms of the contract. And if they can't or won't, they suffer the consequences of breach. execution, getting everything signed, how we calculate days regarding the contract. And then unit or provision 23, again, you're not going to find this in your book. This is a fairly new addition. They used to have the remedies scattered all throughout the contract, but a year or two ago, they created its own separate handy dandy paragraph, which is a lot easier to find the remedies now. So breach by the buyer. If the buyer breaches, the seller is entitled to the earnest money deposit. The seller acknowledges that the earnest money deposit and the due diligence fee serves as the seller's liquidated damages that we talked about in Unit 9, and it serves as the seller's sole and exclusive remedy for the buyer breach. So the buyer breaches, the seller gets, remember, we're after due diligence if the buyer breaches. Due diligence has passed. The seller gets the earnest money deposit, the due diligence fee, and that's their sole and exclusive remedy, which means the seller can't sue the buyer. The seller can't go after the buyer in a court of law for more money, for more damages. I mean, they can try. We can find an attorney, right? You can sue anybody for anything. But the judge is going to pick this contract up and say, it says right here, your earnest money deposit and your due diligence fee are it. Why are we doing here? What are you wasting my time? Listing agents, when those offers come in, make sure your sellers understand the earnest money deposit and the due diligence fee is all that they get. Let's think this through. The seller doesn't have a chance of getting the earnest money deposit until after due diligence. Sometimes we got like a week or two or three's long, but sometimes we have a limited time between due diligence and closing. It's all negotiable. It could be a couple days. It could be a couple weeks. But think about it. By this point, doesn't the seller have to make arrangements to live somewhere else? Don't they either have to go under contract to buy a house or sign a lease? So the closer we get to closing, the more risky it gets for the seller because they got to move out. They got to make arrangements to live somewhere else. So your seller needs to understand, if the buyer terminates the day before settlement, this is all you get, due diligence and earnest money. Is this enough for you to break your contract or your lease? Does that make sense? And that's what they need to understand. Then we talk about seller breach. If the seller breaches, the buyer can either elect to terminate this contract, and they should be entitled to both earnest money and due diligence, along with reasonable and costs incurred during the buyer's due diligence process. So if the seller breaches, they get the earnest money, buyer get their due diligence, plus they could go after the seller for the monies that they already spent, like on home inspections and appraisal and pest inspections, right? They invested money in this contract and now the seller has breached. So they could go after him for the money, or the buyer elects not to terminate, keep this contract remaining in full force, and the buyer can seek the remedy of specific performance. They could choose, they could opt to take the seller to court, sue them for specific performance. We talked about in Unit 9. And when the buyer wins, if the buyer wins, the judge could make the seller sell. The judge could make the seller perform. That's what we mean by specific performance. What's the seller's big obligation? To sell. So they could make them perform. So again, the buyer has choices if the seller terminates. I think we mentioned last week, and I think it's worth mentioning again, the consequences of breach are much harsher for the seller than they are for the buyer. I mean, the buyer can sue the pants off the seller, can't they? The seller gets earnest money and due diligence, and that's it. And guys, the reason being for that, this is done on purpose. And the reason being for that, the seller initiated this whole thing to begin with by putting a for sale sign in their front yard. So the seller started this. We wouldn't be under contract if they didn't say they had a house for sale. So because the seller started this, because the seller's the one that got the ball rolling, they're held to a higher standard as far as breach goes. Legal remedies, if we got to take each other to court over breach, generally speaking, the non-breaching party will be entitled to collect attorney's fees and court costs from the breaching party. So not only can the buyer take the seller to court for the money that they've owed, they could also go after them for the attorney's fees and the court costs. Contracts have to have teeth. They got to hurt if broken. Otherwise, what do they mean? You guys with me? They got to mean something. And what's the best way to hit people? Hit them in their wallet, hit them in their pocketbook. So remedies, again, please make a note, provision 23. I think you guys should, I know you're reading the whole thing anyway, but I think you should look at this as well because it spells out what happens for both. And then I got a place, here we go. I got a place for 2 buyers to sign on the left and 2 sellers to sign on the right. If you have more than 2 buyers or sellers, then we use the additional signatures addenda for as many signatures as you need, all buyers and sellers. Same with our listing agreements. If it's an entity buyer, an entity seller, we'll put that information here. And then here's our wire fraud warning. Again, saw this in both of our agency agreements. We're going to see it now in our offer to purchase and contract. Making sure that the parties just communicate with you so we can help protect their money before they start wire transferring money back and forth from the attorney's office. Again, the recommendation, never, ever, ever, ever email. Tell your buyers and sellers, I will never email you this information. Because if they get an email from you with wire transfer instructions, I need to know because I've been hacked. My email has been hacked. So just making sure we're having this conversation, help protect everybody. Page 15 of our contract is the notice information. How do we want to communicate? Remember, we said any form of communication is allowed as long as the parties agree. So how do we communicate? So I got a place up here for the buyer and seller's contact information. And then we have a place for our information. So the selling firm is the one working with the buyer. And we're going to check the role of the firm. Are we a buyer's agent, a seller sub-agent, or a dual agent? What role is the firm playing in this transaction? We're going to have our firm license number, mailing address, and then we're going to identify you, the individual selling agent, whether or not you're acting as a designated dual agent. You need your license number and your contact information so we know who to communicate with. Guys, this is the only place that brokers belong in the contract, and I'm not signing anything. I'm just identifying myself and my role on the notice information page. Does this make sense? I'm not signing anything. I'm just putting my name in here so you know who to communicate with, so you know who's working, the agent working with this buyer and seller. We go through that same little exercise on the right, the listing firm. Who is the listing firm? And then what is their role? Are they acting as a seller's agent or a dual agent? And then there's a place for you, the individual listing agent. And you're going to indicate if you've been designated, license number, contact information. So how do we know how to communicate with the parties? How do we know how to communicate with each other? Ta-da! The contract takes care of that for us by giving us this notice page. And then the last page is acknowledgement of receipts of monies. When we go under contract, as due diligence fees and earnest money deposits change hands, we need to sign acknowledging them. So let's say you're the buyer's agent. Your buyer goes under contract today. You get your buyer's offer accepted and we go under contract today. Take time and celebrate the small wins. We're not going to do the big celebration until it closes. But we can celebrate the little wins that build up to it, right? So your buyers go under contract today. Yay, we're one step closer to closing. Celebrate the small wins. You will meet your buyer after we go under contract to get the due diligence check made out to the seller and to get the earnest money check made out to the escrow agent. And then you, as the buyer's agent, are going to deliver those checks to the seller and the escrow agent. When you receive the due diligence, listing agent acknowledges receipt of the due diligence fee. You are signing, acknowledging receipt. How much was the due diligence check? And who at your firm, if it wasn't you, actually touched it, actually received it? Can we all agree on its way and in your hand are two totally different things? Can we all agree with that? Guys, there have been cases reported to the commission. The due diligence fee goes missing and it gets reported to the commission. And they look at this form to see where it is. And the listing agent has signed for it. They have signed acknowledging receipt. And the listing agent said, well, I never got it. They said they were going to drop it off after lunch, but it never made it after lunch. Don't sign it until you're touching it. Everybody with me? Because that's what you're signing. You're signing that you have received it, not that it's en route. You signed. So don't sign it until you've touched it, until it's in your hand. Then the listing agent is going to deliver the due diligence to the sellers. So again, it changed hands again. So the seller is going to acknowledge receipt of the due diligence fee. When the buyer's agent drops the earnest money off at the escrow agent is going to sign acknowledging receipt. So we're going to kind of track those monies to make sure they are where they're supposed to be. Whether you have initial earnest money or additional earnest money, they're both earnest money. So the escrow agent needs to sign for it. And that, ladies and gentlemen, is your 16-page offer to purchase and contract. 16 pages for the seller to promise to sell and the buyer to promise to buy. Isn't that something? Every time they do a revision, they add pages. This thing keeps growing. I bought my little condo in 2006. In 2006, the offer to purchase and contract was 8 pages. We have doubled this thing in, what, 16 years? Something like that. Isn't that amazing? Whenever they do a revision, you will be notified. My goodness, if you don't know about it, it's because you're not paying attention to anything going on around you. You're going to get emails. You're going to see it on your Facebook pages. Your firm will probably have a firm meeting specifically to the changes in the contract. Anytime the form updates, you will be notified. We usually get a grace period of a couple months to implement the new forms, but after that grace period, all new forms have to be used. So your firm absolutely is going to make sure you're using the current. Like I said, they'll probably have a sales meeting on it with the changes. One thing that NCAR does when they change a form, they actually like highlight or strike through. So you can look at it and see, like, for example, this provision is no longer applicable. They'd have this whole thing strike through. So you can actually see the changes. And we're not expected to hold up a new contract and an old contract and figure out the differences ourselves. Isn't that nice? So they actually provide us with, this is what changed and sometimes why. What questions do I have on the offer to purchase and contract? I feel like there's a lot of you that are back from break that I didn't know were back. So why doesn't everybody in the chat just say here? When in doubt. Again, your offer to purchase and contract on the online learning system. We're under the Campbell folder. And the highlights, everything's highlighted, which means it's all on the syllabus. Questions? I'm going to stop sharing this for 1 second. Ooh. Let me see. Maybe I can fix that. I hope when I fix my chat, I didn't mess something else up. So it goes. But let me see. All right. So let me come back and get you guys. Maybe I just need to turn my volume up a little bit. Okay. Let me know after next break if you still can't hear it. If not, I'll go back to Jane. Poor Jane. She's so patient of us. She's got to be. All right. So again, review the offer to purchase and contract. You know, we just made that correction, page 292, about the delay in settlement. But otherwise, I think 287 to 293, other than that change, I think that's a good kind of explanation of the various provisions in the contract. Now what we need to do, starting on page 293, we're going to talk about some commonly used addenda. Now, we do not have to look at these forms, but we do need an understanding of what these commonly used addenda do. So that discussion starts on page 293. If you see this on a test question about addenda, I envision what you're going to get is like a scenario, and then it's going to ask you A, B, C, or D, which addenda to use. So we need, again, just a basic understanding of the different addenda. So not only does the North Carolina Association of Realtors and the North Carolina Bar Association provide us with our offer to purchase and contract, NCAR and the NC Bar Association, that's what NCBA is, also provides us with the addenda. There's a forms committee at NCAR, and that's what their job is to edit, add, and delete forms as necessary. As the market changes, as things happen, it could be result of an introduction of a new form, a change in a form, or retiring an old form that is no longer in use. We are certainly not looking at all the addenda applicable. There's a lot more addenda that we're going to look at. So again, we're just focusing on the addenda on 293 over to 295. Sometimes the addenda creates conflict. Sometimes there's conflicting information in the addenda than there is in the contract. The addenda is meant to add to. Remember, addenda, do we see the word add? It adds to and becomes part of the offer, and upon acceptance, it becomes part of the contract. So if there is, when we do find a conflict, the addenda will prevail. It's going to rule over the contract, and that's kind of its point. It adds to and either enhances or embellishes or maybe rewords a sentence or a provision in the contract. So the first addenda we're going to look at, and we're going to talk about this one again when we get to our financing units. But if your buyer is getting an FHA or a VA loan, then we're going to include the FHA or VA financing addendum. And the whole point of this form is to protect the buyer's earnest money deposit if they terminate because it doesn't appraise. So we go under contract, we agree on a purchase price. It doesn't appraise for that amount of the purchase price. This form allows the buyer to terminate even after due diligence period. This form allows the buyer to terminate and get their earnest money deposit back. Again, we're going to talk more about the appraisal. What does it mean if it doesn't appraise? VHA or FHA, VA, all that's coming in unit 14 and 15. The other piece of this form specifically addresses the VA buyer. The VA may require certain inspections, but they don't allow the buyer to pay for it. So if the buyer's not going to pay for an inspection, who's left? The seller. Listing agents, do you think that's important to your seller when you're discussing the terms of this offer? If you accept this offer, you may be on the hook for the pest inspection, for example. So we'll talk more about that. Right now, let's just understand this form is creating this verbiage, protecting the buyer's earnest money and letting the seller know if you accept this offer, you may be on the hook for some of the buyer's costs. So more on this in 14 and 15. A few minutes ago when we were talking about possession, typically the buyer is going to get the property. Get the keys at closing, access to the property at closing, possession. We may be able to, the parties may agree to different forms of possession. So we could have a buyer possession before closing, which means the buyer moves in and occupies the property before the deed changes hands. We may also have the parties agree to a seller possession after closing, which means the deed changes hands, but the seller hasn't moved out yet. Everybody see that? Buyer possession before and seller possession after. In either situation, I got one party acting as the landlord. The homeowner is the landlord, whoever that may be, the owner of record right now. And the other party is the tenant. They are renting from the owner. This form is a very brief form. It is not a full lease. It doesn't cover all the terms of a lease. So because of that, it's meant for short-term use only. We're talking a couple days, maybe a week. Anything longer than that, we need an attorney to draft a lease, because the terms, the provisions just got a lot more. But we're going to hash out, how much rent we're going to collect for those couple days. The landlord is going to collect for those couple days, or pets allowed. Insurance in these situations are huge, which is why we bring this up again when we get to Unit 13. Whomever is acting as the landlord must have homeowners insurance. Whomever's acting as the tenant must have renter's insurance. And that's one of the big things that this form addresses, is making sure that both parties have adequate and appropriate insurance during their short time. But it also hashes out like who pays expenses, utilities, repairs, lawn care, who's responsible for keeping the grass mowed in those couple of days. Again, anything more than short term, we need to have an attorney draft a lease. See this again in Unit 13. Another addenda that we've already talked about is our lead-based paint, or lead-based paint hazard addenda. We talked about this in Unit 20. This is required on all residential sales, anything built prior to, what's that magic year with lead-based paint? 1978. Remember, this form is not saying it was built prior to 1978, so you have lead in it. This form is saying because it was built prior to 1978, you may have lead. This is the one thing that the seller has to disclose. The buyer has the opportunity during due diligence. They want to conduct tests to find out for sure. I'm going to say of all the commonly used addendum, the additional provisions addendum is the most common used of the commonly used addendum. This covers things that are popular, but they're just not popular enough to make it into the standard offer to purchase and contract yet. So some things covered in this addenda. If the offeror wants to put an expiration of their offer, I'm presenting the offer, but I'm saying it's good until 5 p.m. today. If I want to put an expiration date or time on my offer, we can use the additional provisions addendum to list the expiration of the offer. At 5 p.m. today, if we don't have acceptance, the offer's dead. The offer is no more. If there's a septic tank on the property, we have a place for septic tank installation or modification. So if we want to have it tested, if it's raw land and we need to see that the property is suitable for an on-site septic tank, we'll use the additional provisions addendum to allow for inspections, who pays for it, who's responsible for clearing the land. That covers all that. If it's a rental property with a current tenant and valid lease in place, the seller needs to provide the buyer with the information of the tenant in the lease agreement. Understand, in North Carolina, when the buyer buys, they buy honoring the existing lease. They acquire a tenant. So doesn't the buyer have the right to know the terms of the lease? Doesn't the buyer have the right to know if the tenant's up to date on their rent, for example? So the seller needs to provide that information. That's what this one's covering. Agreed upon repairs and/or improvements. Let's remember one thing. We are including this form with our offer. We're not even under contract yet. But if the buyer comes across something, maybe they say something like, I absolutely refuse to buy this house unless they fix this. That would trigger us to use this additional provisions addendum. We're asking the seller to do repairs at the time we're presenting the offer. Maybe you can see something. I had a sliding glass door one time, and it looks like the lawnmower threw a rock at it, and there was a little hole in it, and then it was starting to spider. Sliding glass door. I don't need a home inspector to come in and tell me that that door is broke, do you? So your buyer may choose to ask for that to be repaired. Again, the seller's under no obligation. They just have this information to consider when they're considering all the terms of the offer. We're giving them everything up front. Understand, if we go under contract, this does not negate the buyer's ability to conduct their due diligence, do their inspections and investigations, and they can still ask for repairs. We're just asking for stuff up front. Additional provisions addendum for agreed upon repairs or improvements, things that we know going into it that we want addressed. If there's a manufactured or a mobile home on the property, we have a place for that on this addenda. And then if there's an outdoor pool or spa, and it's the middle of winter, how are we going to have it inspected? It spells out who's responsible for unwinterizing it, re-winterizing it after the inspection. Obviously, if we're buying in August, the working pool should be open, right? But if it's February and you're buying a house with an outdoor pool, don't you want to know if it works or not? So that's what this provision covers. Again, of all the commonly used forms, I think this is the one that is used in practice the most often. I have all these forms available to you. I'll show you in just a second where you can find them. You're welcome to look over them, but you don't have to for your exam. Again, we're just getting a very basic understanding of what these forms do. But I want to make them available in case you do want to look at them and get further in depth. We'll spend more time on these addenda when we get to post licensing. And then, of course, when you get out in the real world and you get to use them in practice, you'll be really familiar with them really fast. Questions on this one, the additional provisions addendum? Another addenda we have is the Owners Association disclosure. This is providing information about the Owners Association. This would be a situation where the RPODS is exempt. The RPODS is the Residential Property Owners Association disclosure statement provided by the seller. And one thing that the seller provides in the RPODS is the HOA information. So if the RPODS is exempt, the number one reason why the RPODS would be exempt is new construction. Never before lived in. So if the RPODS is exempt, the buyer still has the right to know the Owners Association information. That's what this form does. Question comes in, non-permitted addition add value. Yeah, remember, we just have to disclose that it wasn't permitted. Back in Unit 5, if you have unpermitted space, we can count it, we can include it, it adds value. We just have to disclose that it's unpermitted. So Owners Association, Vacation rental addenda. Some of you may live in the mountains. I know a handful of you live down at the coast, you lucky ducks. So you may be dealing with vacation properties. If you're dealing with vacation properties, properties that are currently being used as vacation homes, you're helping buy or sell, we have an addenda for that. Obviously, if you're in that area, you're going to want to learn more about this from your firms. Not all of us, like I said, coast and mountains. I mean, Winston-Salem's lovely, but let's face it, people are not vacationing here, are they? So we just don't see this too much. But there's a form for that. The short sale addendum, again, we're going to talk all about short sales when we get to units 14 and 15. So we'll see this again. Basic definition of a short sale says that the owner can't sell the home and pay off their debt. They're underwater. They owe more than the property is worth. Short sales are unique. Again, we'll talk all about them. If we are in a short sale situation, the short sale addendum creates a contingency. And what that contingency says is the seller can't sell until they get loan approval from the lien holders. So if all the lien holders don't approve, the contingency says the seller's no longer legally obligated to sell their home. It's a process, which is why I want to wait and talk about it when we get to 14 and 15, once we introduce some financing words, financing terms. So we're just introducing you to the addenda now, knowing this will come back up. Don't let the name fool you. A short sale has nothing to do with the length of time that these things take. A short sale is there because the owner is short on funds. The owner doesn't have the money to close. So we'll see this one again. And then the last one that we're going to talk about is our backup contract addendum. Why don't you guys remind me in a chat? Well, it's right here. You don't have to do that. No, it's not. Remind me in a chat. Which offers do we present to our sellers? Which ones do we present to them? Yeah. Which ones do we present? All offers. So if we're already under contract, the seller is contractually obligated to sell their home to a buyer, and another offer comes in. Do I have to present that to my seller? Yeah. Isn't it an offer? And y'all just told me we present all offers, even if we're under contract. So the backup contract addendum, the offer that's going to come in, should include the backup contract addendum. The property is already under contract. We're going to agree to all the terms like we always do. Purchase price, due diligence, dates, earnest money, everything like we always do. And if that offer gets accepted, this buyer is going to be put in a backup position. So we have the primary buyer, who's the original offer, and then we have this backup buyer. And it's funny to say this, but this backup buyer is standing by, fingers crossed, hoping, praying that the original contract terminates. Because what this backup contract says is if the primary buyer terminates for any reason, the backup buyer moves up to the primary position. Some sellers like this, especially in this wild market we're coming out of. We saw new life breathed into this form. You know, you have a seller with a situation where we have, 70 showings in 3 days, and those 70 showings result in 20 some offers. That's pretty intimidating for the seller, isn't it? Guess what? It's intimidating for the agent as well. Of those 30 some offers, how many can we accept? How many can the seller accept? Yeah, just one. So we accept one, which means the other 29 we have to reject. Yes? One of those 29 buyers may say, I want to do a backup contract addendum. So if that primary buyer terminates, I can move up in that position. The seller may like this because if the primary terminates, they have a backup. They have somebody else waiting in the wings. They don't have to open their home to showings again. They don't have to go through the chaos of multiple offers. So again, just a conversation to have with the seller. I will say probably the number one question I get on the backup contract addenda is how many backups can you have? And this form only allows for one backup. Guys, we're not lining them up the street. We can't have a backup to the backup and then a backup to the backup to the backup, right? It only allows us for one backup at a time. If somebody wants to be the backup to the backup, what do you think we're going to do? Make up a form for them to sign? No, we're going to call our attorney and see if they'll draft something up. This form also says the backup buyer doesn't owe due diligence until and if they become the primary. Again, we're agreeing to all these terms up front. They don't owe due diligence until and if they become the primary. If they never become the primary, we will hold their earnest money in an escrow account. If the backup never becomes a primary, they'll get their earnest money back. Remember, that's just showing their good faith. So we'll have that in escrow account. Any questions on this one? Backup contract addendum. As I mentioned, we got lots of forms. The Real Estate Commission has a joke. They do have a sense of humor down there in Raleigh, and they have a joke. And their answer to many brokers' questions is there's a form for that. Because you know what? There's a really good chance there's a form for that. So we got a form, cajillion forms. I don't know how many, but there's a lot. If you have a situation where you have the form doesn't fit, then we need to have an attorney. But again, the North Carolina Association of Realtors and the North Carolina Bar Association has provided us with many forms that applies to most situations. So if you want to do a repair request, ask the seller to do repairs, seller agrees to do repairs, I got a form for that. There's forms to aid in negotiations. There's also multiple forms to terminate. We're not getting into these here, but we got several different termination forms. The parties got agree to release the earnest money. They don't agree to release the earnest money, for example. Several different situations. I'm just easing you guys into the forms. We are an industry of paperwork, for sure. I'm so happy to say that we're now, for the most part, electronic. Could you imagine how much paperwork we had before we were electronic? I mean, some offers can be 30, 40 pages by the time you do the offer and the addenda and the RPOs and the MOG. And think about all this stuff we're adding. We could be looking at a 40-page document just to submit the offer. Thank goodness for the e-world, e-documents. Any questions on our addenda, forms? If you look in the online learning system with me up here and you're welcome, your very first tab, one of the sections we have here is the link to all the forms. So every form currently available by the North Carolina Association of Realtors can be found here. So, you know, for example, if you want to look at that backup contract addenda, it's right here. Finding these forms in this folder, your best bet is to see the number. So do you guys see, like on page 295, the backup contract addenda, that's 2A1T. Sometimes that's easier to find the form. Again, you guys, You're not going to be tested specifically on the forms. I just have them here as a reference if you'd like. If you see a test question on the addenda, it's going to give you a scenario, and we need to know which form is best for that scenario. A backup contract does not owe due diligence. They don't get due diligence until and if they become the primary. So if they never become the primary, they're not conducting their due diligence. They don't have to conduct, they shouldn't start conducting their due diligence until and if they become the primary. Anything else? Yep. Again, I know forms are not the most exciting thing, which is why we're trying to help ease you guys into it. We've looked at our agency agreements, listing agreement and buyer's agency agreement. We've looked at the offer to purchase and contract. Just easing you in. All right. I know we're just a few minutes early for break, but no, I hate to start a new section and not be able to finish it. So let's go ahead and take 10. We come back. We're going to wrap up unit 10. How we doing? This next little section in Unit 10 is kind of a good review. So this is good. Kind of sum up some things that we talked about. So we're coming back. Cameras are on. And I can see you. So I am taking attendance. And we are going to pick back up on page 296. So on 296, we're talking about submitting offers to sellers. We have a duty. Well, first off, we're good. We know we have a duty to present all offers to the seller. Guys, we're special agents when we're working with buyers and sellers. We cannot accept terms on their behalf. We cannot bind them. So we have a duty to present all offers to the sellers. And we have to deliver those offers immediately within our receipt. Now, the rule says immediately, but no later than 3 days. If it's taking you 3 days to deliver an offer to a seller, you better have a good reason. Something like the seller's out of country and you can't get in touch with, for example. Make sure we're delivering. I cannot stress the importance of communication between that offer to contract process. We need to be in touch with the other agent. We need to be in touch with our parties so we can help get them under contract. As we said, we are special agents, which means we cannot accept or reject an offer on the seller's behalf. Even if your seller says, I cannot accept anything less than X amount, when an offer comes in less than X amount, we still need to contact the seller and say, I got an offer for X amount. Do you accept it? They're going to say no. And you're going to say, thank you very much. Have a good day. That conversation is that long. But I still, even though knowing they can't, they told me they can't, we don't know what happened to their financial situation last night. Could you imagine a seller, their financial situation changes last night and they got to sell this house no matter what? And then they find out their agent rejected an offer on their behalf. Do we have a happy seller? Absolutely not. Let them decide what they want to accept and what they want to reject. I'm getting to multiple offers right now. Multiple offers. Very much this crazy world that we're living in. Not all markets have multiple offers. As we get back into a buyer's market, we're going to see multiple offers going away. Multiple offers are not a material fact, meaning if I'm the listing agent and I have multiple offers, I don't have to disclose that. This got a lot of agents in trouble the last couple of years. Buyer's agents were calling listing agents and saying, what's the highest priced, or do you have multiple offers? That's not what got us in trouble. I skipped ahead of myself. May I back up? Rewind. Thank you. The fact that we have multiple offers is not a material fact, which means when the buyer's agent calls you and says, do y'all have multiple offers? You may or may not disclose that. Whether or not we have multiple offers and we disclose that we have multiple offers is up to the discretion of the seller. The seller can choose if they want to disclose that we have other offers. One thing we're going to learn in just a second, where I was just heading, we cannot disclose the terms of an offer without the offeror's permission. So what was happening? Here we go. Buyer's agents were calling listing agents and saying, what's the highest price offer you have in your hand? Can the listing agent answer that question? Can they say, oh, the highest thing I got is for X amount? Not without the terms, not without the written permission of that offeror. Guys, there's no rule that says you can't call and ask. The rule says is that we can't disclose without the offeror's permission. Highest and best offer, absolutely, is what, because it's not just the purchase price, is it? We now know there are other terms to consider, such as due diligence fee, earnest money deposit, contract to closing period length. So when we ask for the highest and best, we're not just necessarily looking at purchase price, we're taking everything into consideration. When we present the multiple offers that we have in our hand to the seller, we're not going to present them in any particular order. We're not going to say this is the first one, second one. We're not going to say this is the best. We're going to present them all at the same time. We're going to consider them all at the same time. Now, I obviously can offer my advice, but understanding the final decision comes from the seller. So if we have called for highest and best by 5 p.m., we still want to make sure we deliver all offers immediately. But what we're saying by highest and best is 5 p.m. is that's when I'm going to discuss them with my seller. That's when I'm going to go over them with my seller. In a multiple offer situation, how many offers can the seller accept? Just one. Just one. We can't have them legally bound to sell their home. In a multiple offer situation, it's advised that we only counter one at a time. Think about this. If we counter 5 and all 5 of those buyers say, I accept, we got our seller in kind of a pickle, don't we? So if we have to counter anything, best advice is to counter just one. Obviously, you're missing it by just probably a little bit, get them a little higher on their prices. So we're delivering at the same time in no particular order. In other words, what I'm saying is I can't favor one offer over the other. I cannot say, look at this one first, and then we'll look at all the other ones. What if one offer is from another agent in your firm? Can I favor that one over the cooperating brokers? What if one of those offers is from a buyer you have been working with? Don't you stand to make more money if you're working with the seller and the buyer? Wouldn't that best benefit you? Remember what we said on day 1 of agency. It ain't about you, is it? So make sure that we're best representing our sellers. We're providing them all the information, not favoring one over the other. And by shopping offers, I mean, we can't pit the offerors against each other. We can't say, this is what this one's offering, you can do better than this. Even if you are the agent representing the buyer and the seller in that same transaction, you can't coach your buyer to have the best offer because you know the terms of the other offer. We provide the facts. We give them a CMA. They decide what they're comfortable offering. Does this make sense? I'm never going to look at a buyer and say, this is how much you're going to pay for a house. It's not my decision to make. They need to decide what's best for them. So disclosure of offers prohibited. This is a commission rule. Again, you don't need to know this. I just put it here for a reference. This is the rule that says I cannot disclose the terms of one offer without the offeror's permission. And this is what got a lot of agents in trouble. Again, buyer's agents will call you and ask you. They will ask you, what's the highest price offer you have in your hand? That's not prohibited. What is prohibited is how you respond. Your answer is, you sat through pre-licensing. You know darn well I can't disclose the terms of that offer. I would put that a little nicer if I were you, but we get the gist. Yes? Don't let people catch you off guard. Contract modifications and counter offers. Again, as we said, with a counter offer, any change to the original offer is a rejection. Maybe you're flat out rejecting the whole thing. Maybe you're counter offering it. You're rejecting the terms of the original offer. If you are negotiating on the piece of paper and numerous changes, anytime you have a change, you strike through, write in the new price, for example. Everybody has to sign or date and initial that change. After a while, after numerous changes, it's going to get hard to read. So the suggestion is that we do a novation and we substitute the old with the new, something that we can read. And we have to retain all offers. What do we document? Everything. So if you get 40 offers, we're only going to go into contract with one, right? But didn't you receive 39 other offers that you rejected? Keep it. Always keep it. Don't ever throw anything away. So you keep all those offers that were rejected. That's part of your transaction file. When you communicated with the agent that their offer was rejected, keep that documentation. Again, this came up a lot in the multiple offer world. Broker in charges were finding out that their agents were accepting one and throwing the other 39 away. No. When in doubt, keep it. Don't throw it away. Who remembers how long we have to retain everything? How long do we retain records? How long do we keep stuff? Got you guys showing me? Yeah, we do it for 3 years. Keep everything for 3 years. Yep. Once we go under contract or even with the offer, we need to make sure all parties get a copy. I think the general rule of thumb here says if your parties sign it, they deserve a copy of it. Makes sense, doesn't it? If you sign a legally binding document, don't you want a copy of it? So we need to make sure that our parties, and again, we have a rule that says we have to provide it to them within 3 days of execution. So you sign, it starts with the agency paperwork. Everybody signs the agency agreement. You have 3 days to send that signed agency agreement to your new client. Says, here's a copy of our signed agency agreement. I look forward to working with you. It's as simple as sending an email with a PDF attachment. You go under contract. We have 3 days to send the final contract paperwork. You go to closing. We have 3 days to make sure. There's a common misconception out there. Some agents think they can wait till the very end of the transaction and send everything all at once. But the commission rule says that we got to send everything within 3 days of signing. They sign it. We got 3 days to send an email with a PDF attachment. You're going to document that sent email showing the date, the timestamp you sent it. Yep. That kind of falls under our document everything category, doesn't it? So make sure you have that for your records. If they say I never got it, you have that. It used to be when we were on paper, we might have several copies. So the buyer might sign a version and the seller might sign a different version. You might have 2 signatures on 2 different versions. Today in the e-world, we're not running into this. Today in the e-world, we're seeing everybody on the same form much more often, much more common. When we go under contract, obviously both agents need a copy of the contract. Buyer and seller needs a copy of the contract. May it be e-version or send them the paper, whatever. The buyer's lender needs a copy of the contract as soon as we go under contract. Again, we're going to talk about that process starting on Thursday and the importance of getting that signed contract to the buyer's lender as soon as possible. The closing attorney needs a copy of the contract. Again, we can send everything electronically unless the parties request anything different. Questions? So we're going to walk through a couple scenarios, and I want you guys, you can give me yes, no answers by shake of your head. So up, down for yes, back, forth for no. Everybody good? So I'm going to ask you guys some questions. Good. Look at you guys. Say, yep, we're good, Julie. We got it. Okay. So I want to ask you guys some questions, and this will be a good review, kind of walk through a scenario, a more applicable scenario. And the questions we're going to ask revolve around, when does it go from being an offer to a contract? Remember that magic moment in time. And remember those 2 things that we need. I'm not going to remind you because that's going to negate this exercise. So we need 2 things, that magic moment in time for it to go from an offer to a contract. So buyer offers a purchase price of $150,000 with $250 in due diligence, $250 in earnest money, $1,500 in closing costs. They want to close in 3 months. They've asked the seller for a home warranty, and of course, they want the refrigerator. Yes or no? Are we under contract? No, buyer just made an offer, right? What are the seller's 3 choices when they receive this offer? They can accept it, reject it, or counter it. Everybody good so far? Sellers received an offer. They have 3 choices: accept it, reject it, or counter it. This seller counters. They say, no closing costs. I'm not giving you my refrigerator, and I want to close in 6 weeks. All other terms acceptable, which means they're good with the purchase price. They're good with the due diligence. They're good with the earnest money, and they are good with the home warranty. See, we started here. Now we've closed the gap just a little bit, right? We got a little closer. So now what are we negotiating? Now we're negotiating closing costs, refrigerator, and 6 weeks to closing. Everybody see? So the seller counters the buyer's offer. Yes or no? Are we under contract? No. Counter offer is a rejection. Is the buyer bound to anything at this point? What are the buyer's 3 choices? They can accept it, reject it, or counter it. So no, we're not under contract. A counter offer has been created. Now the buyer's got to consider these terms. The buyer accepts the terms of the seller's counter. Accepts means what? The buyer has signed. The buyer has signed, and they tell their agent. The buyer tells their agent to go for it. Are we under contract? I got one piece of it, don't I? I got acceptance. Are we under contract yet? Not yet, because what hasn't happened yet? When they tell their agent, the communication, look at you guys go, still needs to cross the line. Selling agent calls a listing agent, says you have yourself a deal, my buyer's accepted your seller's offer. Now are we under contract? We've had acceptance and we've had communication of acceptance. Congratulations, we are under contract. As soon as I get back to the office, I will email you the signed contract. I'm in my car, I don't have it right now. Remember, it's not about delivering the contract, it's communicating acceptance. So the buyer's agent calls the listing agent, says, you have yourself a deal, we're under contract. The moment I get back to the office, I'll send it to you. That magic moment in time. I need acceptance, and then I need communication of acceptance. Questions on our little scenario? All right, I got a question for you guys, and I do want you to set to a private chat, even though you have the ability to chat to everyone right now. I don't want you to give the answers away. Again, I don't want somebody to sit there and base their answer on what everybody else is saying. That's not how you learn. So everybody set your chat to private. Everybody good? And I want you guys to tell me in a private chat, A, B, C, or D. Everybody in? Oh, yeah. Private chat. I threw a curveball at you by getting my Zoom fixed, didn't I? So now you have choices when you chat. To everyone or just me? All right. I know this isn't a math problem, but what do you think we do when we first see this? What do you want to do first? Just read it. Just read. Breathe and read. Read and breathe. On Sunday, a listing agent receives a written offer for $145,000 on a house listed for $154,900. Not this market. On Monday, the seller counters at $149,900 and gives the buyers 3 days to accept. On Wednesday, the buyer rejects the offer, the counter, and upon being informed, the seller says, no, I'll go back and accept the buyer's original offer. Under these conditions, what do we have? Nothing, because a counter offer is a rejection. Once the seller countered the buyer's original offer, that original offer is dead on the table. In a counter offer, there is no going back. Remember, a rejection, it's dead on the table. Let me ask you guys this. In this case, could the seller make a brand new offer to the buyer with these terms? Could the seller make a brand new offer to the buyer? Yeah, absolutely. Absolutely. And it's reasons like this that I don't want you guys to get bogged down in buyer and seller. I want you guys to think offer or and offeree. Offer or is the give or, offeree is the receiving. Questions on this? Okay. The last little piece of Unit 10 is some alternative land conveyance methods. Not everything is the traditional buy-sell that you're going to see 99% of the time. The rest of Unit 10 is all green stars, which means we can go through this pretty quickly. You may see a test question or two, very basic understanding of these different forms of alternative land conveyance methods. Also understand not all possibilities are discussed here. This is just a few kind of get you guys thinking outside the box, knowing not all transactions are traditional transactions. So is everybody good if we bebop through this? Bunch of green stars, basic understanding. So the first alternative land method, conveyance method that we have is something called an installment land contract. And with an installment land contract, the buyer's buying, the seller's selling. The buyer's going to pay the purchase price, but they're not going to do it in one lump sum. They're going to pay it in installments. They're going to make payments to the seller until it's paid in full. Obviously, we have to agree to how much per month, for how long, is there any interest, et cetera, et cetera. In an installment land contract, the seller keeps the title, keeps the deed until that last payment is made. So the buyer's going to have possession. They're going to have equitable title, which means they have permission to live there. They're going to treat it as if it were their own home. And when they make that last payment to the seller, then the deed changes hands. So the seller keeps the legal title. If the buyer defaults, the seller still has the property. They can re-rent it, resell it, whatever. This is awfully similar to seller financing. We're going to talk about seller financing in units 14 and 15, and we'll have a little refresher here. The difference in an installment land contract and seller financing is when the deed changes hands. Installment land contract, deed doesn't change hands until the last payment's made. Seller financing, the deed changes hands, and then the buyer makes payments for however long, for the term. So the difference in the two is when the deed changes hands. So if we look at an example, buyer agrees to purchase real property and to pay the seller the sum of $105,000 in the following manner. We're going to do it $5,000 at the execution of this contract, the balance of $100,000 together with an interest rate of 12% until paid in full. Principal and interest shall be payable in 240 installments of not less than X amount per month beginning on this date. Pretty specific, isn't it? Buyer's going to pay the seller this amount for the next 240 months. When that last payment is made, we'll go back to the attorney's office and the deed will change hands. There's some advantages and disadvantages for both parties, buyer and seller, in an installment land contract. Let's start with the seller. Some advantages to the seller, they still own the property. They're still the owner of record. So they may have some tax benefits, have them call their accountant. This could help the seller sell a hard to sell property, giving the buyer time, if you will. The biggest advantage to the seller is they keep the legal title. They keep the deed in their name until that last payment is made. The disadvantage to the seller, they're going to get it in payments. They're going to get a loan down payment. They're going to get it in installments. So if you have a seller that needs all the money right now, they may not be able to agree to do an installment land contract. As a listing agent, if we get an offer to do an installment land contract, do we have to present this to our sellers? Do we have to present it? I see head shaking yes. Because what offers do we present? All of them. And an offer to do an installment land contract is an offer. If your seller has a lot of legal questions about how these things work, we need to have them talk to their attorney. And if the seller does get an offer to do an installment land contract, what are their three choices? They can accept it, reject it, or counter it. So does the seller have to do an installment land contract? No, they have the choice to reject it. We present it again, you guys. I'm providing the information for them to make the decision. So advantages and disadvantages for the seller, advantages and disadvantages for the buyer. This could be good for a buyer if they have poor credit. Maybe a lender won't give them a chance, but a seller at a 12% interest rate will. The buyer may also be able to take advantages of some tax advantages. They don't own the property yet, but they're living there. So they may even be paying property taxes. That might be part of the agreement. Have them call their accountant. Disadvantages. The biggest disadvantage to the buyer is in the event of the buyer's default. If they stop making payments, by law, the seller has to give the buyer 30 days to get caught up. And on day 31, if they don't have the whole note due, the seller can terminate, kick the buyer out, and they don't have to refund any money that the buyer's already paid. That money's in their pocket and it's spent. So the biggest disadvantage to the buyer is if they default. And the buyer doesn't own the property yet, so they can't use it as collateral. They don't have legal title yet. So if they need extra money, they can't borrow against the home. Question comes in, is this the same as seller financing? As we said, it's close. The difference in installment land contract and seller financing is when the deed changes hands. So I will introduce you guys to seller financing when we get to units 14 and 15. I do not have a pre-printed form, or the North Carolina Association of Realtors does not have a pre-printed form for an installment land contract. So if we're called to assist in one of these, what's one of the very first things we need to do? We're going to draft our own verbiage? No, we're going to get our attorney involved, right? Because the attorney is going to have to draft up the paperwork. Installment land contract. The buyer's buying. They're just not paying in one lump sum. They're paying in installments. Another alternative land conveyance method is something called an option to purchase. Remember in Unit 9, we talked about bilateral and unilateral contracts? And I said, I got one example of a unilateral contract. Well, here we are. Our option to purchase is a unilateral contract, meaning how many sides have to perform. Unilateral, uni means just one. One side has to perform. And in this situation, the buyer has not agreed to buy. The buyer has simply requested the option to decide if they want to buy. At the end of the option period, they either create a bilateral contract and they proceed to buy, or they don't. The option period is giving the buyer an opportunity to decide if they want to buy or not. We're going to agree to all the terms at the beginning of the option. Again, the buyer is going to say, if I choose to buy, I'm going to buy at these terms. The only promise, what makes this a unilateral contract? The only promise made with these, the buyers made no promise to the seller. However, the seller promises sell to anybody else during this option period. So we have an option period of 1 week, 1 month, 3 years, whatever the parties agree to. And the commitment, the promise made by the seller is that they won't sell the home, the property, to anybody else during this option period. The buyer's locking them in. What in the world would make a seller agree to do this? What in the world would make a seller agree not to sell for a period of time? Nothing talks louder than money, does it? So one other thing that makes these unique, in addition to the sales price, there's also an option fee that's paid to the seller. The buyer has to pay for this option. Again, at the end of the option period, they either form a legally binding bilateral contract, now the buyer's committed to buy, or they don't. Connor Act kicks in with the option. Statute of frauds kicks in, which means these option agreements have to be in writing and recorded. By recording an option, that prevents the shady seller from selling it out from underneath the buyer. So we're going to make sure the seller's locked in. I don't have a pre-printed form for this, so we got attorneys involved anyway. They're going to help us record. As a listing agent, if we get an offer in for an option to purchase, do I have to present this to my seller? Do I have to present it to them? Yep. And if we do present it to the seller, what are the seller's 3 choices? They can accept it, reject it, or counter it. Don't let these names fool you. An offer is an offer is an offer is an offer. So an offer to do an installment land contract, an offer to do an option to purchase is an offer, of course. I think a good example, I mean, this could happen in any situation. But let's say, for example, you work for Big Corporate USA. And Big Corporate USA wants to open a warehouse in Charlotte. So they send you to Charlotte to find their location. And in your research and investigations, you find 2 locations that at a glance could be a good fit for what Corporate USA, where you work, wants. So maybe Corporate USA enters into an option with both of those good properties. So they can have more time to like fully inspect, fully investigate, not just the building, but the logistics. Do they need stuff, highway access, airport, whatever, to get product to and from the warehouse? So they're buying time, basically, is what they're doing. And we've gotten 2 options At the end of the option period, corporate USA may decide to move forward with and purchase one and not the other. The buyer's just buying time. The last alternative land conveyance method we have, we actually got two, but they fall under a big broad category of a preemptive right. So let's talk first about what a preemptive right is. A preemptive right is just a contractual right to acquire property. Maybe you don't want to buy now, but you want the opportunity to buy later. Maybe the seller doesn't want to sell now, but when they do decide to sell, preemptive rights would give you the contractual obligation to have the opportunity to buy first. So we're not selling just yet. We're just creating these preemptive rights before it can be offered to anybody else, before it can be bought or sold to anyone else. Now, as mentioned, we have two different types of preemptive rights. The first one is called the right of first refusal. The owner doesn't want to sell right now. And what a right of first refusal says, that if the owner does decide to sell later, if the owner does get an actual bona fide offer in their hand, this preemptive right says they are contractually obligated to come to you first and give you the opportunity to match or beat that offer. So you don't want to sell right now. Maybe you don't want to buy right now, but you don't want somebody else to buy. We're not agreeing to the terms. We're just saying, look, if you decide to sell later and you get an actual offer in your hand, you're contractually obligated to come to me. Give me the opportunity to match it. Right of first refusal is more common. I mean, again, we can do it in any situation, but I think a good example of right of first refusal would be a lease situation. You have a tenant in place and that tenant's been there for 2 months, 12 years, whatever. And the tenant may not want to move when their landlord decides to sell. So the two could enter into a right of first refusal. Seller goes to sell, they get an offer. They got to give that tenant the right of first refusal. Match a bona fide offer. The other preemptive right is right of first opportunity to purchase, which gives the contracting party the first opportunity to purchase. Again, maybe you don't want to sell just yet, but when you do decide to sell, you're contractually obligated to come to me. One of the differences between this one and the right of first refusal, with these, we've decided if I do buy, this is the price I'm going to buy for. We've already hashed out the terms. I'm not trying to match an offer. Maybe you don't even have an offer. But the point is you didn't want to sell when I wanted to buy. So now I contractually lock you in. When you do decide to sell, you have to come to me first. Again, I don't have forms for these. So any of these scenarios, we got attorneys involved. I don't want you guys to get so bogged down. I'm going to do a nice side-by-side comparison in just a second so we can see the differences. But basically what you're doing is you're contractually putting yourself first. If the seller decides to sell later, or if you decide to buy later, you're contractually putting yourself first in line. The difference between the two, the right of first refusal, the contracting party has the opportunity to match a bona fide offer. An offer has already been made. And before the seller can respond, they're contractually obligated to come to you first. First opportunity to purchase, we've already decided the price. We've agreed to the terms. So if you decide to sell later, this is what you're going to sell it to me for. I would expect 1, maybe 2 test questions. the highlight, the star of Unit 10, you guys, is the offer to purchase and contract. And understanding that contract formation, that magic moment in time. Now, I did not just say, don't look at these, don't study these, because you could give yourself a test question or two to help pull you up. But of Unit 10, all these alternative land conveyances or green star methods, or green star. Level 1, very basic understanding. Questions? Bona fide means you have an actual offer in your hand, a legitimate, serious buyer. Bona fide is legit. You're not calling your buddy and saying, pretend to make me an offer. You guys with me? You have a seriously legit offer in your hand. Questions? Welcome back. All right, guys, guess what? Mini celebration time. Woo! We've made it through units 7, 8, 9, and 10. They're tough. They're in depth. They're heavily tested. They equate to about 40% of your end of class exam. 40% from 4 units. Does everybody hear what I'm trying really hard to tell you? We are done with agency. We are done with contract. You guys must keep going back and review. So those key terms for unit 10 are on page 269. Key point review. Again, I like the key point reviews in the books. It gives you a nice summary. The key point review is not meant to supplement the unit, but it gives you a nice summary. You can use that as a guide to gauge yourself. And then, of course, the student quiz, starting on page 304. Now that we've been through 7, 8, 9, and 10, I've mentioned on numerous occasions, just a few seconds ago, that these are heavily tested units. I'm reminded of the power of repetition. Guys, we've spent, what, 3 or 4 weeks just on these 4 units. Remember, we are recording. We got our YouTube channel. Go back and listen to agency again. Go back and listen to contracts again. Take advantage of that YouTube channel. I cannot tell you how many times I've had retakes, say the second time around it clicks. The second time they hear it are when things start clicking. And I think that's great. But you have the ability to hear it again now. So please take advantage of that YouTube channel. I'll try to remember to put the link in the chat again if you guys need it. I'll try to do that on break. If I forget, somebody remind me. Questions, comments, concerns? So what I want to do now, I just want to, you guys put your pencils down. I just want to get your wheels turning, get you thinking about some things. And we're going to spend just a little bit more time on that contract communication wall. That contract communication wall that we've been looking at so far is under the assumption, under the understanding that one firm represents the buyer and a different firm represents the seller. This is the scenario we've walked through in class. The buyer's the offeror, which is the giver of the offer. The seller's the offeree, which is the receivee. Buyer makes an offer to seller. Seller has 3 choices. They can accept it, reject it, or counter it. Let's say for timing, this seller agrees to accept this offer. By accepting it in pre-licensing world, we know that that means what? By accepting in pre-licensing world, we know that that means that they have signed it. So we have step 1. of that magic moment in time. Seller calls their agent. That's not what I wanted. Seller calls their agent and says, we have signed it. Are we under contract? Did communication cross the line? No. This is where I think you guys should draw this out. In your practice problems, in your practice questions, I think you should draw it out so you can map along with it. So the seller accepts it. They call their agent and say, we've accepted, we've signed it. Then the listing agent calls the selling agent. Did communication cross the line? Did we go from one side of the line to the other? Yes. So are we under contract? Congratulations. We are under contract. I'll get you the actual contract later. What's the very next thing the selling agent's going to do before they go too far? Don't they need to notify their buyer of the good news? Guys, remember, communicating when it comes to accepting a contract, when it comes to communication of acceptance, talking to me is just as good as talking to my client. So when you tell me your guys have accepted, we're under contract. My very next call in this case is to my buyer, not to say, are you sure you still want this? My call to my buyer is to say, congratulations, you're under contract of your dream home. Now we start with the contract to closing process. This is the scenario that we've been working. I'm almost certain this is the scenario you're going to see on your test, which is why we did so much emphasis with 2 different firms. However, I want to get you guys thinking. I'm not spending a lot of time on this because I don't think you're tested, but I know you have a few practice questions with different scenarios. And again, it also kind of gets you thinking outside the box a little bit. And what I want to do is bring in agency and the contract communication wall. Because right now with 2 different firms, one representing buyer, one representing the seller, it's pretty clear that communication has to cross the line, the communication line. But what happens if we switch up the different forms of agency? Well, for example, in dual agency, where'd the line go? Remember, dual agency is all about the firm. In dual agency, ABC is the firm. The line of communication goes away because we're just dealing with one firm. So now the seller calls their agent and says, we've accepted. Are we under contract? Yeah, because communication in dual agency is about the firm. Dual agency is never about the individual agent. Dual agency is always about the firm. Again, obviously, once we contact the firm, then what's the next call we need to make? Same thing, right? We just don't have that extra step. There is no line to cross because the firm is equally straddling that communication wall. They're equally working with both parties. So with dual agency, communicating to the firm, communicating acceptance of an offer is communicating to the firm. Look at what happens when dual agency becomes designated. Everybody ready? In designated dual agency, the line comes back. The communication wall comes back. Because in designated dual agency, now you have one agent designated to work exclusively with the buyer. And then you have an agent designated to work exclusively with the seller. That exclusivity brings the line back. The firm and all the other agents are still straddling that line. But as far as communicating acceptance, each party has exclusive representation again. So this looks awfully similar. You know, like we said, once you've been kicked off the wall and you've been designated to work exclusively with the buyer, and a different agent in the firm has been kicked off the wall to work exclusively with the seller, both these agents proceed, they might as well be with 2 different firms. And that's why exclusivity comes back, and that's why the contract communication wall comes back. The last scenario, and I know you guys got a practice question on this one because I get calls on it. The last scenario with the agency and the contract communication wall is if we have a seller subagent. Seller subagent means it's a buyer customer. Seller subagent says that the buyer is chosen to go unrepresented. So now in this case, buyer's making an offer to the seller. They're doing it through and they're communicating with the seller subagent. You guys, as a seller subagent, where's your loyalty? Where's your interest as a seller subagent? It's to the seller. So why are you helping this buyer write up and present an offer? Because that's what's in the best interest of your seller. Everybody with me? That's what's in the best interest of the seller. This is the person that you're hanging out over here representing. So we make an offer, seller accepts it. Seller's going to call their agent because that's who they know, right? They're going to call the listing agent, the one that they've been communicating with, and say, we've accepted. Listing agent calls the seller subagent, the one working with, not for, but with the buyer. Are we under contract? Did communication cross the line? No. What's the very next thing the seller subagent needs to do? Cross that line, let the buyer, let their unrepresented buyer, remember they're unrepresented. They chose to go through this without representation. They chose to be over here by themselves. I know you guys have a practice question on this one. You may see some on dual, designated, etc. Again, I'm almost certain for your exams, you're going to have a scenario of two firms that we have been working. But I just want to get you guys thinking. I just want to get you guys seeing how this contract communication wall forms. Question comes in, is this the same as a for sale by owner? For sale by owner, yeah, you're going to have a, so if the buyer's represented, we have ABC Realty. We have the buyer acting as the offeror. And then over here with no representation, we have the seller acting as the offeree. So there is no agent to communicate with. So in this case, buyer makes an offer, seller has three choices. Seller accepts it. Are we under contract? Sellers accepted the offer. For sale by owners accepted it. Are we under contract? Nope. Seller contacts. Got my little symbol here. Seller contacts, here we go, ABC, and says we've accepted. Now are we under contract? So this communication wall, maybe there's an agent involved, maybe there's not. And this is where I think drawing out the contract communication wall is helpful. Where do we find these PowerPoints? All of my PowerPoints are in the Campbell folder and the online learning system. And this is in the 7, 8, 9, and 10. This is the last thing you'll see in those PowerPoints. Plus we're recording, so you can go back through. Does it get you thinking a little bit? Again, ABC, XYZ, two different firms. I'm almost certain that's what you're going to see. But guess what? In the real world, could you have different scenarios? Could you have dual agency and designated dual agency and for sale by owners? So this kind of gets you thinking a little bit. Questions? That's correct. Because in dual agency, please write this down. Dual agency is about the firm. Dual agency is about the firm. All right, we're going to take 10 minutes. When we come back, I need you guys to come back because when we come back, we need to have this conversation. Thank you. We need to have this conversation about how to apply for your state license. What do you do when you pass this class? All that good stuff. So we're going to take a pause from the material and we're going to discuss the application process when we get back. Rosie, I will reload it then. So let's take 10. All right. We are back. Somebody just asked about those slides with the contract communication. Well, I apologize. I thought they were in the online learning system, but they're not. So I will get them in this afternoon. Thank you for bringing that to my attention. I don't know what time this afternoon. Y'all got to let me eat lunch. I got to eat lunch. So I'll get them in this afternoon and then you guys will have them. So just hit refresh if you're logged in. Fair enough? Thank you for bringing that to my attention. Yes, ma'am. Anna, you have a question. No? You guys see the YouTube channel link in the chat? If you guys get that over break, grab that, copy it, save it. Of course, if you need it outside of class, just shoot me an email or a text. So let me take attendance. And perfect. All right. So before we jump into financing, I always say when we're about halfway through the material, then we need to have this conversation about what you guys do when you pass this end of class exam. You guys received from Lane, when you registered for this class, you received an email attachment with this booklet in it. I'm telling you guys right now, they have updated this booklet just since we started class. So you can ignore the attachment from the email you got in Lane. And when it comes to this, I want you guys to look in the online learning system under the welcome sections. Everybody see this? So under the welcome section, it's the real estate licensing in North Carolina. And guess what? We made an acronym out of it. So we call it the RELINC book, Real Estate Licensing in North Carolina. This is the book that says, yay, I passed Julie's test. Now what do I do? And that's where this book comes into play. Some of you are more ready to start your real estate careers than others. Some of you are rip-roaring ready to go. If that's you, you may want to consider starting your application now. Some of you may want to wait until you pass, and that's fine. What we're going to do, we're going to walk through some of the highlights of the book. Again, you guys were asked to read this book. The Real Estate Commission thinks you should read it. Lane told you to read it before class started. But what I want to do now is walk through the highlights of this book. And I did put these PowerPoints in the online learning system last night. So again, they're under the Campbell folder. You have the recording, plus you have the PowerPoints, and you have the booklet. So you should know when it comes time to take your end of class exam, to take your state exam, what you need to do. So we're talking about your RELINC book. And guys, other than the application process, there's other good stuff in this booklet too, which means there's other testing material in this book. Now, some of this we've already talked about, some of this we will talk about, but yet this is another resource to help you guys get through both your exams. Let's all understand. Have you guys figured out by now? There's not a single one of us that deserves a real estate license. We earn a real estate license. And we earn it by proving to the real estate commission that we're worthy of it. And guess what? Once you get your license, you got to work to keep it. Nobody is entitled to a license. Nobody's entitled to keep their license. Get out of your own way right now. You got to earn it. And how you earn it is proven to the commission. So this booklet is straight from the commission. And it's there step by step. You can see instructions for filing an application, licensing exam information, and then licensing process. So one of the first things, by the way, the page numbers down here are the page numbers of the booklet. So if you're making note, this is where we can find various information on the booklet. One thing we've already talked about, who needs a North Carolina real estate license? And the answer to that is the ones that are involved in the transfer of real property for others for compensation. And when we talk about the transfer of real property for others or real property, we use the mnemonic LL Beans. list, lease, buy, exchange, auction, negotiate, and sell. We talked about that back in Unit 8. We'll talk about it again when we get to license law and commission rule. So not everybody needs a license, do they? I think as we decided before, does the for sale by owner or the for rent by owner need a license? Do they need a license? No, because they're not doing it for others, are they? Who are they doing it for? They're doing it for themselves. If you're going to work for free and not receive any form of compensation whatsoever, you don't need a license. Don't do that. Call me if you think that's what you want to do. But we need to understand who needs a license. That explains it on page 3. Also, as we've mentioned, North Carolina is a broker state. We're all brokers. Other states may have sales associates that later become brokers. But in North Carolina, we're all brokers. We just have different categories. So some of our broker categories, provisional brokers, soon to be you guys. Once you get your license, you're going to be handed a license on a provisional status. You're still a broker. You're just a provisional broker. This is the entry level status. I call you guys my brokers with training wheels, because once you get your license, you can ride your bike, but you can't ride your bike alone just yet. As a provisional broker, your license will activate only when you affiliate with a firm or a broker in charge. So let's back up for a second. You go, you take your state exam and you pass. Yay. Congratulations, here's a real estate license on inactive status that you can't do anything with. Good job. How do you do something with that license? How do you activate it? You affiliate with a firm or a broker in charge. To drop the provisional status, you've got to complete the 90 hours post-licensing. So we've introduced you to post. We're going to talk more about it when we get to license law and commission rule. Once you complete the 90 hours of post-licensing, you drop that provisional status and you're just a regular old broker. Also referred to as a full broker. You're a broker who's lost their training wheels. Maybe you affiliate with a firm, maybe you choose to go on your own. More on that when we get to license law and commission rule, what your options may be. For those of you reading the comments, you'll see that discussion in the comments. So full broker, and then at some point in your career, you may want to become the broker in charge. Again, we're all brokers. It's just different classifications, different categories. The broker in charge, you have to have a little bit of experience. You have to have an active license. You have to have a couple things. There's a BIC course that you have to take. Again, that full discussion is coming in the license law and commission rule. And then the other license, if you will, each firm has to have a license. So all real estate firms, entities have to have a license as well. More on that. So the different categories, we're all brokers. The booklet lists the license qualifications. In order to have a license, you have to be at least 18 years old. You can be 17 to take pre-licensing, but you can't get your license until you turn 18. You need to be a U.S. citizen with a social security number. You got to satisfy education requirements, which for most of us is completing this class. If you're licensed in another state, actively licensed in another state, you may be able to come to North Carolina and avoid pre-licensing. So you satisfy the education requirements. Again, for most of us, is passing this class. You submit your application, you go take your state exam. It's broken down into two parts. There's a national section and a state section. And then, as we said, you have to earn your license, which means you have to prove to the commission that you have good character. So when you submit your application, they're going to ask for your character. They're going to make sure that you're in good standing. Remember the commission's main purpose. What's their main purpose? To protect the public. So why are they going to hand you a license if you don't think you have good character? Why are they going to hand you a license if you can't pass these exams, proving to them that you have the minimum competency? So that's what we mean. You got to earn it. You got to prove to the commission that you deserve it. And going through these steps, going through this application process is a huge part in convincing them that you deserve a license. Please make a note. In your RELINC booklet, starting on page 7, we talk about the application process. There are steps involved, and you have to go in order. So many times we get phone calls, Lane and I and the commission. Well, I'm trying to do this. Well, have you done steps 1, 2, and 3 yet? No. You got to do it in order, and they spell out the steps for you starting on page 7 of the RELINC book. So we're going to go through the steps. Step 1, you got to complete this course. Satisfactorily complete this course. How do you satisfactorily complete this course? You take the midterm, which I'm going to talk about again in just a minute before we leave today, and you pass the end of class exam, and you meet the attendance requirements. Once you satisfactorily complete the course, Lane will send you a certificate of completion. The certificate of completion is the last thing you need to complete your application. You cannot submit your application until you got the certificate of completion. You're not going to get the certificate of completion until you pass a pre-licensing course. Do I have everybody with me? So you are all currently in the throes of step 1. Part of your application is going to ask for my instructor code and the school code. Both those codes will be on the certificate of completion you get from Lane when you pass. So step 1, complete this course, get your certificate of completion. By the way, your certificate of completion is good for 3 years. So if you're not ready to get your license just yet, you can wait a couple months, you can wait a couple years, you can wait 2 years and 10 months. I do not recommend waiting 3 years. Things are going to change between now and 3 years. You're always going to be tested on the current. So if you wait and things change, you may not be up to date on the current. Failure to do it, failure to get your license in 3 years means you got to come back and take pre-licensing again. So you get this certificate of completion that's good for 3 years. I have everybody. You have 3 years before you have to come back and see me again. So step 1. Step 2, you're going to submit your application to the Real Estate Commission. I'm going to show you in just a minute where you submit that application. I'm going to show you where all of you can get started. It'll save the work, but you can't actually submit it until you finish this class, until you get your certificate of completion. Once you submit your application, then the commission staff will process your application. Guys, they're only going to look at completed applications. If you submit an application that's not complete, they're going to send it back and they're going to require you to complete it. So you submit your application, the staff reviews it, and upon approval of their review, they will send you a notice of exam eligibility. The notice of exam eligibility is the golden ticket you need to schedule your state exam. You cannot contact the testing center. The testing center doesn't know you exist until you get your notice of exam eligibility. This is the step that many students miss. This is the step that Lane and I and the Real Estate Commission get the most often. You pass my class, and then you call the testing center. And then you get upset because they don't know you exist. They can't schedule you. So this is why going in steps and the process is important. So the commission reviews, they accept your application. They send you a notice of exam eligibility. Now you can contact the testing center to schedule your exam. I'm going to talk more about that testing center in just 1 second. So you get your notice of exam eligibility. You contact the testing center to schedule your exam. Again, more on that, just 1 second. You go to the testing center on your scheduled date and time, and you pass. This is not a mini celebration, by the way. This is the big deal celebration. This is your first celebration in real estate. Once you pass the testing center, assuming they don't need other information, assuming they don't have questions about your character, they're going to mail you your license. They will mail you a nice 8x10 license. You can expect that in the mail within, 5 to 10 days, give or take. So you go to PSI testing center and you pass, or you don't. It's okay if you don't pass your state exam. You get second, third, fourth, however many chances you need. Guys, please don't be so hard on yourself if you don't pass a state exam the first time. It's tough. And I'm going to tell you guys right now, these exams are in no way any kind of indication about what kind of real estate agent you're going to make. I know top producers that have had to take this test and this class multiple times. If you pass, it's not a good day if you fail. The first time I went to the state exam, I failed. I have no problem telling you guys that. And that, you know what, was a really bad day. But you know what I did? I picked myself up, I dusted myself off, and I went back to the testing center until I passed the second time. You guys with me? You don't want to fail. I get it. So try again. It's okay. No broker in charge, no buyer or seller are going to ask you, how many times did it take you to get your license? All they want to know is, do you have a license? Everybody with me? So y'all don't get in your own ways on this one. It's not a good day. I'm telling you right now. I left the testing center. I was boo-hooing. I called mom. Isn't that what we do when we're upset? And y'all know mom. I'm like, oh, and mom's like, maybe you did better than you think you did. It's like, I already know. It was a bad day. It was a bad day. But you know what? The next time I went, I got it. And that's what you guys got to do. I'm getting questions and I'm getting to your answers. So please bear with me. It's all in the book. Please bear with me for 1 second. If you fail, you just reschedule. We'll talk about rescheduling, getting you back in just a second. So you just reschedule until you get it. So pages 7 and 8 gives you the application process step by step. Understand you got to go in order. You got to take the steps. The other part of your application, or another part of your application that you'll need to submit to the commission, they're going to require you to do a criminal background check. They tell you, the company, to order your background check for. It's all part of your application process. So there's a specific company that they'll use. Your background check is good for 6 months. I don't think you guys should order your background check yet, because you're still about a month away from submitting your application. So if you're rip-roaring ready to go, you may want to hold off on ordering your background check. Again, I'll show you in just 1 second where it all starts. So they're going to do a background check. They look at your last, I think it's 7 years of addresses where you've lived in the last 7 years. So if you've lived in other states or other countries within the last 7 years, your background check is going to cost more and is going to take you longer to get back. I don't know how much each state charges. I don't know the time frame, but just know that going into it. If you've lived somewhere else, another state or another country in the last 7 years, it may take you longer to get your background check back. Things that they're looking for with your character, again, they're looking for criminal offenses, anything you got yourself in trouble with the law. They want to make sure you know what you're doing, professional license. Or if you got yourself in trouble, anybody have another professional license, another occupational license? This isn't your driver's license, but this is like a CNA or a CPA, another license. If you've gotten yourself in trouble with your other professional license, they may consider that as well. And then they're also going to look to see if you've had any unpaid liens or judgments. Now, understand, if you have a blemish in your past, if you have a criminal offense, you're not going to get a license. They're just going to review it. They're going to consider it. If you have a blemish in your past, please do not call Lane and I and tell us what you did. Lane and I have zero control about whether or not the commission issues you a license or not. So if you have a blemish, if you had a run-in with the law and you have a concern, on pages 11 through 13, you can do what's referred to as a petition for predetermination, which means you're asking the commission to review your offense before you submit your application. They can give you a yes, we'll allow it, no, we won't. Guys, usually if you've done the time and you've, proven yourself a good citizen to society, they may not. I mean, I'm not the commission. I can't say one way or the other, but it's not an automatic no. That's what I know. So background check, again, if you're concerned about your past, pages 11 to 13 of the RELINC book, you can request a petition for predetermination. So they've reviewed your character, you've submitted your application, they determined that you're so far so good. They send you the notice of exam eligibility. Again, that notice of exam eligibility is the golden ticket you need to schedule your test. PSI Testing Services is who issues your test. There are locations all over the state of North Carolina. I'll talk about that in just a second. Your testing center is going to offer, there's not just the real estate exam going on. It's a testing center. So the person next to you might be taking the CNA license. The person on the other side of you might be going for a CPA license. So it's a testing center. They offer different tests. Our exam is broken down into two sections. There's a national section and a state section. For the national, you have 80 testable questions. For the state, you have 40. The reason we have the plus, when you get there, you may have 83 questions and 45, for example. Anything over 80 or over 40 are going to be test the test questions. You guys are vetting test questions for future test takers. It's not going to count for or against you, and you'll have no idea if it's a test the test question. Previous test takers did it for you guys. You get to do it for future test takers. So they're just vetting test questions, which is why you're going to see more than 80 or 40, but those are the only ones that are scored. In order to pass the national, you need a 57 out of 80. Pass the state, you need a 29 out of 40. In order to get your license, you must pass both sections. So you go to PSI Testing Center. Let's say, for example, you pass the national, but you fail the state. You only have to go back and retake the state. Isn't that good news? You only have to go back and retake the section that you failed. If you fail both the first time, you got to retake both. If you just fail one, you just have to start or keep, I guess, with the one that you failed. Also in the RELINC book, I think we've already looked at this, pages 16 to 17 gives you an actual breakdown of how many test questions you can expect to see of each topic of the syllabus. So property ownership and interest pretty much is what we call units 2 and 3, for example. This will kind of help you, 16 and 17, and I didn't put it all here, but this will help you guys with your study time. When you look at 16 and 17, you know what sections you're going to see are going to have a lot of test questions? Sections from units 7, 8, 9, and 10. You're going to see lots on agency, contracts, but this kind of gives you a guide, help you know where to focus your energy, your testing energy. I'm just talking about your state exam right now. I'll open up questions for our end of class exam in just 1 second. That's a good point. Thank you. Let's make sure we're all good. This conversation is just about the state exam at PSI Testing Center. When it comes to applying for your exam with PSI Testing Center. Remember, you cannot contact PSI Testing Center until you get the notice of exam eligibility from the commission. Is everybody hearing me? This is the #1 call down at the commission. #1, don't call PSI. Don't call the real estate commission. You wait patiently for your notice of exam eligibility. That is your golden ticket to get into PSI Testing Center. Your notice of exam eligibility is good for 180 days, which means you have 6 months to pass both sections. If you don't pass both sections within 6 months, you have to go back through the application process again and get a new notice of exam eligibility. So your certificate of completion is good for how many years? The document you get from Lane saying you completed this class, it's good for how many years? 3 years. So however many notice of exam eligibilities you can squeeze into that 3 years. Again, you don't have to retake the class until after 3 years, but you got 6 months. If you don't do it within 6 months, you apply for another notice of exam eligibility, and that does include another background check. So if you don't pass both sections, you got to submit a new application. You go back to pages, you start back over on pages 7 and 8. You don't have to start back over from day 1 of pre-licensing. Is that good news? They give you 3 years before you got to come back. Exam's good for, exam eligibility is good for 6 months. Here's your carrot. Every single time you go to PSI Testing Center, every single time, I don't care if you're taking both sections or one. Every time you go to PSI Testing Center, it costs you $156. So if you're taking both sections, how much is it going to cost you? $156. If you just have to take one section, how much is it going to cost you? $156. Let me help your wallet. Don't apply until you're ready. If you leave this class and you're not ready, you don't feel ready, you feel like you got by it on a wing and a prayer, don't spend the money. If you feel good, or once you've been studying, reviewing, because guys, understand, when we finish class, you have got to keep going. Hopefully you've built these good study habits. You're in the practice, you're in the habit, and you keep going. Do a mini celebration when you pass my exam, but that's just getting you one step closer. $156 every time you go to PSI Testing Center. Scheduling your exam with PSI, that should say PSI. Slide am I on so I can make an edit? 23. They will give you in the booklet starting on page 19. They will give you step-by-step instructions of scheduling your exam, when you can schedule it, how you can schedule it. That's all starting on page 19 of the booklet. They used to allow you to test at home online. This past May, they did away with it. So now your only option is to physically go to a testing center. Trust me, that's in y'all's best interest. The online was awful. People were, they were losing connection, but their clock didn't stop. So they were losing time. It just wasn't a good, they got nothing but complaints. So they did away with online testing this past May. Gosh, that's been almost a year, hasn't it? So now your only option is to actually go to a testing center. PSI Testing Center will work with candidates with special accommodations under the Americans with Disability Act. We're actually going to talk about ADA in future units. So that could be a good testable point. If you have a special accommodation, you need to contact PSI so they can make arrangements before you go, so they can make arrangements on accommodating you. What all is needed, what all they look for, it's on page 25 of your RELINC book. On test day, you're going to go to the testing center. You're going to get there 30 minutes early so they can check you in. They're looking for some certain forms of identification. That's all spelled out on pages 25 and 26. And you also get that when you schedule your exam. They'll send you step-by-step instructions for check-in. The suggestion is that you arrive early so they can get you checked in, get you started so you can start your exam on time. They're not quite patting you down yet as far as security goes, but they're awfully close. Anything you take into that testing center, they're going to make you put in a little locker. You can't take stuff with you to actually take your exam. So you may want to leave, what you can at home. Like I said, they're not quite patting you down yet, but give them time. I don't think they're too far away. By the way, when you submit your application, back to step 2, when you submit your application, use your full legal name. Don't let the commission try to figure out who you are by a nickname. Do you know how well that's going to go over with them? Yeah, no, they're not going to like it. So make sure you're using your full legal name. As we said, as far as exam security is huge. Y'all want to know the #1 issue the Real Estate Commission and PSI Testing Center has with the exam? Rule #1, don't cheat. Come on, don't attempt to cheat. What do you think they're going to do? What are they going to determine about your character if they catch you cheating? Is that good character to go work with their public? If they catch you cheating, you guys, you're probably not going to get a license in the state of North Carolina. Don't do it. It amazes me how much energy people put into cheating. Why don't you use that time to study instead of trying to figure out different ways to cheat? They don't take too kindly to that. So we can't cheat. Please remember, your state exam, and for what it's worth, my exam, are confidential exams. You cannot discuss anything about either exam with anybody. That includes Elaine and I. There is no discussing the exams. Guys, there was a bulletin a couple months ago. They took down an entire study group because it was found out after they took their exam that they were caught cheating. And so their brand new license were immediately reprimanded. Isn't that something? I don't know how they found out. I have no clue, but you know what? They found out. And there was probably 11 or 12 people that got their license reprimanded, part of that study group. Isn't that something? No idea how they found out, doesn't matter. So everybody pinky swear me. Julie, I'm not going to try to cheat on your exam or your state exam. Can I get everybody's promise? Thank you. Blows my mind. We have to have these conversations, but apparently we do. Taking the exam, you get 2.5 hours for the national, you get 1.5 hours for the state. If you take a break during either section, your clock does not stop. However, your clock does stop in between each section. So the suggestion is you plan to take your break after the national and before you start the state. Everybody with me? You get a period of time. Again, if you take a break in the middle of national, your clock keeps ticking. So once it starts, timed sections, as is my exam. So then on page 26, they kind of talk the breakdown. Yay, you passed. They're going to send you a license. That's when you can celebrate. Getting this email or this text from you guys is why I do what I do. Because I get a text or an email from you guys saying, Julie, guess what? I passed my exam today. And I say, yay. And I'm going to celebrate with you. Because guys, remember, I've been there. I know where you are. So I'm going to celebrate with you guys. Absolutely. I know what it takes to get it. So yay, they're going to mail you your license. Looks something similar to this. Get you a frame for it. You worked hard for it. So I say display. You guys can see mine right here. You guys see that over my shoulder here? Yeah, I'm that proud of it. I hang that sucker up. If you don't pass, then you just contact PSI to schedule your retake. They will make you wait 10 days before you can go back. That's kind of a cooling off period, but you can go ahead and schedule it today. So if you don't pass today, you can go ahead and schedule it. The earliest you can take it is 10 days. Again, you have 180 days from or for your notice of exam eligibility that's good for. So you can get in as many times as you need to. After that 180 days, you got to resubmit your application again. Both exams, my exam and PSI, you're going to get a report. Nobody can let you review the questions once you've seen them, but you'll get a report that'll kind of give you a breakdown, tell you how you did on agency and contracts and the different topics, help you study for the retake. Do you have to pay to retake the exam? Every single time you go to PSI Testing Center, it costs you $156. So does it pay to retake? Do you have to pay to retake? Yes. You cannot walk in the front door of PSI Testing Center without paying $156. Do I have everybody? So you pass, yay, you get your licenses on provisional status. It's inactive. Congratulations, there's nothing you can do. So as we said, as a provisional broker, how do you activate it? You have to affiliate with a broker in charge. Also, as we said, how do you drop your provisional status? You take post licensing. We'll talk about that when we get to license law and commission. Some of you may knock out post licensing in your first 6 weeks. Others of you may take over a year. You have 18 months to complete all 90 hours, 18 months to complete post licensing. So they give you a year and a half to do 90 hours. Don't let that time get away from you. Failure to take post licensing within the 18 months means your license is inactive until you get it done. The last thing, and I'm opening up for questions. I see questions coming in. I'll certainly open it up. The last thing that this booklet covers talks about the renewal period. Again, we're just introducing this to you. We'll spend more time with this in license law and commission rule. The real estate commission's physical year is July 1st to June 30th. So what I mean by that is the real estate commission doesn't operate on a calendar year. Their New Year's is July 1st. Their year ends on June 30th. And each year, once you get licensed, each year you have to renew your license. And how you renew your license is to pay your fee during the renewal period. The renewal period every year is May 15th to June 30th. So starting on May 15th, you can renew your license. You have until 11:59 p.m. on June 30th. Last year and the last, I can't tell you how many years, as far back as I can remember, the renewal fee has been $45. So you have 45 days to pay $45. Isn't that handy? Get that $45 in. Your license is renewed. I did not say it's active. I did not say it's inactive. You're just renewing it. Renewing your license makes your status current. Failure to renew your license makes your status expired. So to have an active license for July 1st this year, step one, you need to renew. If you don't renew, your license is expired. Again, spending more time on this when we get to license law and commission, just introducing you to it because it's in the booklet. This is one of these testable topics, which is why we're going to spend more time on it. So we're paying the fee from May 15th to June 30th every year. That means at the stroke of midnight on July 1st, your license is current. If you don't pay the fee, the stroke of midnight on July 1st, your license is expired. Do you think you can practice real estate on an expired license? You think you can work with buyers and sellers? Do you think you can get paid on an expired license? Yeah, you guys are good. Nah, we can't. So if you don't pay, like I said, your license is expired. If you do pay, your license is current. And what we're going to learn is that a current license can be either active or inactive. Paying makes your license current. Doing your required education makes your license active. Once you're licensed, you have to do CE. So there's 2 steps to having an active license. Step 1, pay the fee. Step 2, do CE. Like I said, we'll spend more time on this when we get to our license law and commission rule. I think a common misconception is that post-licensing and CE are the same thing, and they are not. They are totally different things, 2 different departments at the Real Estate Commission. Post-licensing is a one-time requirement for newly licensed agents. Continuing education is something we have to do every single year. So I'm going to show you in just a second where you can start your application process. We will talk much more about post-licensing and CE, but this is just getting us through this booklet. So I've got a couple questions. Let me address this. Do you have to retake the class? Remember, your certificate of completion is good for 3 years. So you don't have to retake the class until your certificate of completion runs out. So you, Pat, when's our test? May 23rd, give or take? Does that sound right? You get your certificate of completion on May 23rd. You have 2024, 25, 26. You have until May 22nd on 2026. Does that make sense? That's what we mean by that. If you don't do it within that 3 years, you got to come back and retake the class. Is there a price for the test? Yep, $156. Do we go to the testing center for my exam? No, we're going to take my exam online via Zoom. We are going to use a class marker link, which is the same link you guys have for the midterm. And I'm getting ready to show you where that is. That goes live at 1 p.m. So we'll talk about that just in 1 second. I will talk about the rules and expectations for my exam, the very last thing that we do together, because I need those to be fresh in your mind. So we're not going to talk about my exam, specifics of my exams until we get there. Do you find out your scores immediately? Yes. You hit submit, both my exam and PSI. You hit submit, it says, are you sure? You say yes, and boom, pass or fail, slaps you in the face. It is literally that fast. I told you guys I failed the first time I went. I didn't even have time to process the fact that I had finished, not alone that I'd already failed. So it's immediate. It's good and bad, right? Y'all ever have a conversation with Lane? She's been licensed long enough. She had to wait for her results in the mail. A big envelope means that you had a license. A little envelope means that you didn't pass. Could you imagine? So thank you, Internet. I love when Lane talks about that. I'm old, but I'm still young enough that I had my test immediately. Is there a grace period that you have to wait to retest? Yep, they make you wait 10 days. Do you have to pay to retake? Yep, $156. How many retakes do you get? As many as it takes within that 180 days. So remember, they make you wait 10 days. So if you go on day, 3, they make you wait 10 days. Now you're on day 13, right? So as many times as you can get in, that 180 days, if you don't get both sections done by then you start back over on step 1, resubmit an application and resubmit your background check. If you take post, do you still have to work under a firm? Some provisional brokers take post licensing before they affiliate, which means they're taking post licensing inactive. Others of you might be ready to affiliate, which means you can take post licensing with an active license. It's been my experience when I teach post licensing, I literally have 50-50, 50 active, 50 inactive. So what route you want to go is entirely up to you. Is there an exam with post-licensing? Yes. Each post-licensing class has a test, but I'm here to tell you right now, post-licensing isn't near as intense as pre. Now, with that being said, I still need you guys to commit to post because you still have tests to pass. So I still need you to commit and do the suggested activities, but it's not near as intense as pre. And guys, when you go into post-licensing, you know how well you got agency and pre, for example. If you really struggled with agency and pre-licensing, do you think you need to work a little harder with agency and post-licensing? So you guys know how you're doing in pre, you know how much you need to study or focus for post-licensing. We got to get you through those tests. Let's see. What if we fail the class? Well, remember with my class, you get an option for a retake. So if you don't pass the first time, but you make at least a 50%, you can retake. So what if you don't make a 50% or you don't pass the retake, you got to retake the class. You got to keep going through this class until you get that certificate of completion. How much is the application fee? It's either $100 or $56. I'm not sure, but there's two fees. One's an application fee and one's like a processing fee. So one's 100 and one's 56, and the two together, that $156 every time you go. The retake for my exam, that's correct, is May 25th. Look at your tentative schedule. We got those dates there. After 18 months of being affiliated, you can still go through post-licensing? No, because if you don't do post-licensing within 18 months, your license is inactive until you get it done. So if you're going to activate your license by affiliating, I mean, I would hate, guys, there's horror stories out there about you guys being in the throes of a transaction, and then your license goes inactive because your 18 months has passed. You think you can get paid for that transaction if you're inactive? No, somebody's got to take it over. Maybe you can get paid, but let's just go ahead and all agree we're going to do our post-licensing well within 18 months so that time doesn't get away with us. I get it. You get busy, you're working with buyers and sellers, and post-licensing is the last thing on your mind. I need you guys to remember post-licensing until you get it done. And this is where we have differences. Some of you want to bust it out as fast as you possibly can. Others of you want to get started and go back and take your time. There's no wrong way to do it. Just do it. If you have to take my class again, what is the fee? Lane does offer you a discount. I don't know exactly how much it is. If you retake it with Carolina School of Real Estate, if you go to another school, obviously you won't get the discount. I want to say the retake is $180, but please don't hold me to that. But it is a discount, so she will let you retake the class. A couple of you saying $175. Okay. If you don't do post-licensing in the 18 months, do you have to come back through pre? No, you're just inactive until you get post done. Keep asking questions if you got them. It's a lot, I know. And that's why the commission provides you with this handy dandy booklet. If you guys call Lane and I, you're going to hear pages rustling. You know what pages you're going to be hearing rustling? The pages from this booklet. Everything you need to know is in here. It's a process. Please always remember that. So how do we get started, Julie? I got 5 minutes, so I got to go, so bear with me. ncrec.gov. You go to Google, you can search the North Carolina Real Estate Commission. ncrec.gov. And you scroll down almost to the bottom, and it all starts right here. There's no reason why every single one of you can't click on that button and start. Start looking at the things that they're looking for, the information that they want to gather. Like I said, it's like the last, I think it's 7 years, addresses. You can save your work. So you can start your application today. You just can't finalize it and submit it until you get that certificate of completion. Question comes in, do I have to affiliate to go active? As a provisional broker, yes. As a provisional broker, you're not active unless you're affiliated with a firm. So ncrec.gov, apply for a license. I'll hang around after class if there's questions, but I got 3 minutes. So in 3 minutes, your midterm link is going to go live. So I need to show you where to get the midterm. Remember, your midterm is the material we've covered so far. It's a must. It's mandatory. What does that mean? You have to do it. Guys, I'm not looking for pass or fail. I don't care if you pass or fail. I'm looking that you try. Guys, this midterm is not for me. This midterm's for you. I would like you guys to treat this midterm as if it were a real test. Give yourself, dedicate 2 hours and sit down and say, if I were taking the final exam today, how would I do? And you can use this as a gauge. Once you complete, you and I both will get a report. So I'll see your scores. I'll know that you attempted. That's all I'm asking. You'll also get like a breakdown. So it'll tell you what percentage of unit 2 you got right, what percentage of unit 3 you got right, and so forth. So if you bomb unit 6, what does that tell you? Go back to unit 6. Okay. Your midterm link is going live in 2 minutes. You guys see the 50% review and midterm exam? You guys see this tab under unit 10? When you're ready to take your midterm, you're going to go to the Campbell only. Class marker midterm exam, Campbell only. This thing goes live in 2 minutes, and it'll stay live until 11:59 p.m. Monday night. So you have the rest of Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday, and all day Monday. You have 6.5 days to do this 2-hour exam. Mandatory exam. Is everybody hearing me? Don't make me track you down Monday afternoon, please. Okay, I got 1 minute for questions, and of course I'll stick around. Always stick around. But what question? I knew I just threw a lot at you guys. Welcome to real estate school. You ever feel like you're drinking from a fire hydrant? That's what it's about. What questions do I have? Other questions do I have? Take the midterm, go to ncrec.gov, click on that button. You can't submit it, but it can't hurt you to click on it now and see what kind of information they're going to gather from you. Some of you may want to start it or do your background check in a couple weeks. Some of you may want to wait until you pass the class. Again, there's no wrong way to do it. Whatever you're more comfortable with. Please don't call me and ask me what you think you should do. I don't know. I'm a good agent, aren't I? I provide you the facts so you can make the decision. See how that just worked? All right, that's what I got. We start financing on Thursday, units 14 and 15. We jump into it. With financing comes math. Bring your calculators. 1 p.m. Y'all have a good afternoon. I will see you guys Thursday at 9 a.m. Let's see. Can you pass a question and go back to it before we submit? Yes. So let me. If you guys look, oh, wait a minute, hang on. If you guys look at the email from Lane, let me find that email from Lane real quick. The same email that you guys use to access class. There's that. Let me come back and get you guys. So what you may want to do before the midterm, if you haven't already, this is the email you guys got, and you use this to access class every single time. And within this email, is a, here we go, kind of a little tutorial to class marker. so you can see how the program works. And again, this is what we're going to take our final exam on as well. So it kind of shows you how you can skip a question, you can bookmark a question, how you can go back to it if you want to before you hit submit. So yes, you can go back, you can save it all before you submit. You may want to watch that little tutorial before you take your midterm. But the other thing I like about the midterm is that's the vehicle that the final exam is going to be delivered on. So that gives you experience and exposure to that as well. Are the questions from me or are they randomized pool questions? So our end of class exam is from Carolina School of Real Estate. Your state exam is randomized pool questions. So they have like thousands of questions in the test bank. And every time you sit down, you could see, you know, it's a different random selection. Part of that is to prevent cheating. So I can't take the exam and then run out the parking lot and tell you what's on it. You know, you're going to get so many questions on agency. I just can't tell you exactly what questions on agency you're going to see. Does that make sense? My exam, yeah, it is what it is. But PSI, they got that random pool. So if you have to go back and retake it, are you going to see the exact same questions you saw the first time? It's going to be a different test, isn't it? Which is why we focus on the topics like agency and not this specific question. No matter how many times you take it, you're going to see questions on dual agency. So it's not about getting this one question. It's about getting dual agency. Does that make sense? And that's why we give you the report. And that's why we don't let you review the questions because they don't do you any good. We want you to identify your areas of weakness so you know what sections to focus on. Anything else? We're good. You guys are free to go if you don't have anything else. Remember, I'm available outside of class too. Absolutely. Y'all have a good afternoon.